Yes, before we move on to public business, Deputy Doublé has raised by an email concern over the answer to written question 82, which was a question directed to the Minister for Health and Social Services. I've considered that over the luncheon adjournment, and the Minister was asked to explain what analysis had been undertaken to assess how the needs and rights of younger children would be affected by winter strategy and other things, and where and how the analysis had been documented. The answer, although it talks about the placing of children in the decision-making process, does not indicate any analysis, in other words, explain what analysis has been done, nor does it indicate where such analysis, if it has been done, has been documented. It seems to me, therefore, that the answer does not directly address the question. I direct that a revised answer be provided tomorrow. Very well. We now move on to public business. There is a preliminary matter before we start debates. There's an amendment lodged by Senator Ferguson, for which notice has been given that a proposition will be made to lift Standing Order 32 so that it can be listed for debate at this sitting and to reduce the minimum lodging period. Senator, do you wish to make that proposition? Senator Ferguson, do you wish to make that proposition? Senator Ferguson? Well, very well, we'll have to deal with that in the absence of the Senator or inability to communicate anyway. We'll have to deal with that close at the time. Accordingly,
was that me? I'm sorry, sir. Was that me you were calling on?
Several times, Senator, yes.
I'm terribly sorry.
Not at all, not at all. I was asking whether you wish to make your proposition to deal with your amendment within the, in order that it be listed for debate and reduce the minimum lodging period to be dealt with today, today's or this session. So do you make that proposition?
Yes, please, sir.
You wish to say anything about it?
Well, it seems a little, it goes with the rest of the proposition. It shouldn't take very long, and it would make sense to do it all together. And I will be very grateful if the states would, allow me to cut the lodging period.
Very well. Does is that proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition? Well, if no one wishes to speak on that proposition, I propose to take that as a standing vote. If anyone wishes a recorded vote on this, would they please indicate now in the chat? Otherwise, I will assume it to be adopted on a standing vote.
So can I ask for a recorded vote, please?
Yes, Dadia, you can, in which case I will ask the greffier to place a vote in the link. The link is there. I open the voting and ask members to vote on whether the Senator may be able to deal with her amendment at this sitting.
Sir?
Yes.
Sorry to interrupt, sir. I probably dropped off to sleep. What's the proposition on, sir, please, just before we vote?
Well, best you know before we vote, I think, Deputy. The proposition is proposition brought by Senator Ferguson to enable her amendment to the road safety matter to be dealt with at this sitting, because it was tabled too late to become automatically listed.
Thank you, sir.
Thank you very much, Deputy. Very well. The voting is open.
Sorry, sir, this is St Saviour's. I'm having a job to vote, but I vote for the Senator's proposition to be taken.
Thank
I'm
you,
just
Connetab.
having difficulty. Thank you, my love.
Thank you. It's although Connetab, it's not my love. It's whilst we're doing a formal sitting as this is. So if members have had the opportunity of casting their votes, ask the Secretary to close the voting. The proposition is adopted, 38 votes pour, 1 vote contre, 1 abstention in the link, and a further vote pour indicated by the Connétable St Saviour in the chat. Therefore, the proposition is adopted.
Can we have the contra votes, please, sir?
And the
Yes.
abstention.
And the abstention, contra and abstention.
The vote contra was Senator Mezek and the abstention was Deputy Tadian.
There you go.
I thank the House very much for that.
Well, Senator, very well. We now move on to public business. I remind members, and we'll shortly reach a point where it's no longer necessary to remind, if indeed it still is, that there are the usual time limits for speeches, and the greffier will ring a bell when the time is up. The first item of public business is the encroachments on the foreshore revised policy P111 lodged by the Minister for Infrastructure. Before we start, I'd like to remind members that Standing Order 106 applies to the current debate on the foreshore. So if a member owns a property which encroaches on the foreshore or which they think may encroach on the foreshore, they should declare an interest and withdraw from the debate. Well, I've already had one indication in the chat from Deputy Pennell. Does anyone else have any declaration that they wish to make?
Sir, it's Senator Gorst here. My computer is playing up slightly, so I would like to make the declaration that you have just indicated. Of course, I'd also like to point out that there is no map. There has been no negotiations to know whether it's right to make a declaration or not, but nonetheless, I've made a declaration previously. And therefore I make it again and won't be taking part in this debate.
Thank you very much, Senator.
Sir?
Chief Minister, you indicate that you have a question?
Yes, if you can hear me. All it is that it's basically making a declaration, so sorry, that I own a property, or sorry, I'm director of a company that owns a property on the coast. So I have previously been advised that there is no encroachment, and therefore that I'm not conflicted in the discussions we've had at Council Ministers or in the debates that are projected to take place today, sir. So I'll just make that note if it becomes a question, anyone who wants to challenge that, but that's the advice I've received, sir.
Yes, it's not a question of whether a member owns a property on the coast. It's a question of whether it might be an encroachment is the issue. Whether it might be on the foreshore. If you're advised that it is not on the foreshore, then there is no question of a conflict.
Thank you, sir.
Very well. A number of members have indicated that they wish to make a declaration in the chat. I'm not going to call on anyone to speak. I'll assume that in the chat those declarations are made and they'll be recorded accordingly. The Deputy of St Wan, did you have something that you wish to?
Sir, it was only to make a declaration that a close family member owns coastal land, but we don't believe that there is any encroachment on the foreshore with it, but it's a declaration I've made before. Thank you, sir.
Well, thank you very much, Deputy. As I say, the issue is whether any property a member might own or the spouse might own is on the foreshore or might be on the foreshore, not whether it's on the coast. If it's clearly not on the foreshore, then no issue arises, but thank you for the declaration. Connétable Grouville, did you have a declaration or comment that you?
Yes, well, it's a bit of advice really, sir. By virtue of my office, I'm president of the Kennels of La Fief de la Reine, which owns the golf course, which obviously does border the the foreshore. It's actually Crown land, but I thought I should mention it, although I don't see it prevents me from listening to the debate and taking part, sir.
That's Crown land, I believe, Conitab, and I don't think you have a direct interest in it. So thank you for that declaration, but it doesn't disqualify you, in my view.
Thank you, sir.
On the assumption that we've done what's necessary by way of declarations, and they are now recorded from the chat and from the comments made in the Assembly, then I would indicate that the main respondent is the chair of the Education, Housing and Infrastructure Scrutiny Panel, and I ask the greffier to read the proposition.
The State Trust to decide whether of opinion to approve a revised policy for encroachments on the foreshore as set out in the appendix to the report accompanying this proposition.
Minister.
Thank you, sir. May I begin by thanking officers for the considerable time and effort that's gone into reviewing the foreshore policy. The reasons for the review are listed in the report, and I don't propose to spend time now repeating them all. But the review of the policy was comprehensive. Since then, we have received the Deputy of Grouville's amendment to P111 and the Environment, Housing and Infrastructure Scrutiny Panel's own review. The Deputy's amendment and the scrutiny review has provided a second considered appraisal of this complex and difficult matter. I found most of the scrutiny panel's recommendations to be sound and have taken steps to adopt them by way of my amendments to the proposition. I will go into that in more detail when we debate the amendment later on. So the 2015 policy and this revised draft have been worked on by officers with knowledge and experience of the nature and extent of foreshore encroachments, and with the fullest understanding of the complexities of the matter and the best options for resolution. Considerable work has gone into both the original policy and this revised draft. And as members will recall, the Solicitor General gave a presentation late last year on the revised policy and said that it was a policy with which his department would be happy to work with in conjunction with Jersey Property Holdings. As members will have seen, the policy starts by explaining its purpose and then sets out certain key definitions which are later referred to in the policy items. These are all fundamentally important definitions necessary for understanding the implementation of the policy. It goes on to set out the various categories of encroachment, ranging from new recent encroachments to historic encroachments to minor encroachments, and then subdivides into interfering and non-interfering. It also distinguishes between openings, gates, steps, and stairs, which is a type of encroachment which has been found to be quite prevalent on the foreshore, and also surface water discharge pipes. The policy then gives a preamble to the background to the principles of the policies, the public's ownership of the foreshore, prescriptive title, planning permission, and the role of Jersey Property Holdings. This background is all very important in the application of the policy items. Finally, the policy sets out what will happen in terms of resolution options in each category of encroachment. These options are clear and allow JPH and the Law Officers Department to apply them to commence the difficult task of approaching third-party owners and seeking to resolve matters. The policy is not an income-generating exercise or any of the other misstatements portrayed in the media regarding foreshore encroachments. The policy is simply intended to provide a formal basis to be able to resolve third-party encroachments through a range of options. Certain encroachments will be best resolved through complete removal and reinstatement of the land. But our assessment is far so far as these cases will be very, very few. Others will be best resolved through selling the encroached land to the third party at a fair price, thus giving that party good title to the land and enjoyment in perpetuity. This also applies to where a property is being sold and the purchaser is insistent on having good title to all the land comprising the property, including any strips of encroached foreshore. Others will be best resolved through an informal license, which gives the party use but not occupancy of the land. It is without doubt a highly complex matter and unfortunately can only be dealt with on a case-by-case basis, but with a policy framework under which officers must work. So we debated at length the Deputy of Grouville's proposition P101 2020 towards the end of last year. One item of that proposition being to bring forward a policy. I proposed certain amendments to the Deputy's proposition, which amendments were all approved. I suggest to members that we do not wish to repeat the debates of many of the complexities and issues surrounding foreshore, which were covered last year, but should focus on this revised draft policy and whether members are happy for Jersey Property Holdings and the Law Officers Department to apply the policy going forward. Policies continually need revision and tweaking, and it may be that after a further period of application, there needs to be further review of this one. But I must stress that I see this debate as being about the policy presented here, and not a debate about the foreshore generally. The policy has been prepared by experienced and qualified surveyors and lawyers from JPH and Law Officers Department, who have somewhat difficult task of seeking to resolve many foreshore encroachments, many of which have existed for significant periods of time. It is a complicated matter and a difficult matter, and if the states do not support the resolution of encroachment through the policy, then nothing is going to succeed, and encroachments will simply continue to get worse. So, sir, I urge members to approve this proposition and the revised policy and to allow the good work of resolving foreshore encroachments to continue. I make the proposition, sir.
Very much. Minister, is the proposition seconded?
Yes, sir.
Yes, sir.
Very well. There's an amendment now lodged by the Deputy of Grouville, and I ask the referee to read the Deputy's amendment.
A, after the words "this proposition," insert the word "and," designate the existing paragraph as paragraph A, and insert a new paragraph B as follows. B, to request the Minister for Infrastructure to provide a map setting out the public boundary as part of the encroachment policy document. B, on page 2 of the appendix to the report accompanying the proposition in the section entitled Definitions. 1, delete the heading and associated definition of default boundary line. 2, delete the heading and associated definition of fair and proper price. 3, within the definition of historic encroachments, delete the words "for more than 10 years" and substitute "prior to 12th of June 2015. 4, delete the heading and associated definition of new recent encroachments. 5, delete the heading and associated definition of title encroachments. C, on page 4 of the appendix to the report accompanying the proposition, delete entirely the paragraph entitled Categories of Foreshore Encroachment. D, on page 5 of the appendix to the report accompanying the proposition, delete entirely the paragraph entitled Preamble, the Principles of the Policies. E, on page 5 of the appendix to the report accompanying the proposition, delete entirely the paragraph entitled The Public's Landside Ownership of the Foreshore. F, on page 7 of the appendix to the report accompanying the proposition, delete entirely the paragraph entitled Jersey Property Holdings. G, on page 8 of the appendix to the report accompanying the proposition, after the heading Policies, delete the remaining text and substitute the following. Encroachments occurring after the date upon which the states approved this policy document will be required to be removed, and the foreshore restored to its prior state at the cost of the encroaching party. Encroachments occurring prior to the date upon which the states approved this policy document, but after the 12th of June 2015, will be dealt with as follows. 1. Minor encroachments will be permitted to remain subject to such reasonable conditions as the Minister may specify in a licence agreement. 2. Interfering encroachments will be required to be removed and the foreshore restored to its prior state at the cost of the encroaching party. 3. Non-interfering encroachments, which are not minor encroachments, may at the discretion of the Minister be permitted to remain, subject to such reasonable conditions as he may specify in a licence agreement, including the payment of reasonable compensation. Encroachments which occurred prior to 12th June 2015, historic encroachments, will be dealt with as follows. 1. Minor encroachments will be permitted to remain subject to such reasonable conditions as the Minister may specify in a licence agreement. 2. Interfering encroachments may be required to be removed and the encroaching party may be required, depending on the particular circumstances of the case, including the length of time that the encroachment has existed, to contribute appropriately to the cost of such removal. 3. Non-interfering encroachments, which are not minor encroachments, will be permitted to remain subject to such reasonable conditions as the Minister may specify in a licence agreement. Notwithstanding the above policies, if an encroachment at any time affects any duty of the Minister to repair or improve flood defences pursuant to the Drainage Jersey Law 2005, he may deal with the matter as he thinks fit.
Deputy.
Thank you. When we as members are writing or agreeing or scrutinising new policies on behalf of the public, what is it we actually look for in that policy? What have we been looking for in the many new policies that were brought forward during the COVID crisis, for example? Might I suggest that any new policy made by the States of Jersey has got to first of all be necessary, it has got to be fair, open and transparent, and it has got to transmit a message that can easily be understood. The objective of any new policy is therefore to bring clarity to any given situation. Regardless of its complexity, it should relay a message to enable the public to know exactly where they stand in a given situation at a given point of time. It should also give clear direction to those who have to work with that policy, including the officers of the department, as to how they should administrate that policy on behalf of the Minister and on behalf of the public, hence the title Public Administration. Failure to bring clarity is a failed policy and not worth the paper it's written on. What we have been presented by the Minister for Infrastructure is one such policy. It fails at every level. It fails the public who seek clarity, and it fails the officers who have to try and administrate such a policy. Not surprising when one considers how the Minister's policy came to be. To refresh members' memories, I shall try to encapsulate a brief background to this saga. It was 15 years ago, in 2006, that Property Holdings Department were given a directive by the then Minister to extract optimum benefit from property assets. A laudable objective, I suppose. However, no policy was put in place, and so the ministerial directive was open to interpretation. On the 12th of June 2015, the foreshore was gifted to the people of Jersey by the Crown for the purposes of researching renewable energy projects. Up until that point, the states had acted as guardian to the sections of the foreshore that were owned by the Crown, and therefore the states had, or should have had, a duty to protect it. During this leasehold period, the states had gone about granting planning permissions and also cashing in on the derived stamp duties when properties were sold, and a pragmatic and more general approach was taken to encroachments, as it was recognised that the boundary is a movable feast and can be difficult to determine. However, from the day government gained ownership of the foreshore, it used the opportunity to go about extracting monies from people in a random and inconsistent manner, and still no policy or terms in which to do so, although there are some notable exceptions to this extraction directive. For example, St Albans and the reclaimed area around the parish hall, Ports of Jersey for the reclaimed land they occupy, La Colette, the waterfront, certain hotels along Hoverday Park, areas up to Sand Street and Pier Road, St Bullard's Bay, and what about Greve de Lec? Are we using the high tide mark on the sand dunes that once stood, or the more recently constructed sea wall as the boundary? And so it goes on, because this isn't just a matter of steps up on the beach in St Clement we're talking about. The actions of Jersey Property Holdings became so heavy-handed and inconsistent in 2017 when unsuspecting individuals came to sell their homes who were being made to pay independent valuations which they were not permitted to have sight of, where bills were being uplifted by the department, where one person with a deemed encroachment was being charged, yet their neighbour with an identical encroachment was not, that these two individuals I've been working with decided to take their cases to the Jersey Complaints Panel. The panel's recommendations were published in April 2018 and concluded that the actions of Jersey Property Holdings and thereby the minister towards the two individuals were unjust, oppressive and improperly discriminatory and contrary to the generally accepted principles of natural justice, and their complaints were accordingly upheld. And those complaints, along with the opinions of the Jersey Law Society, the lobby group Save Our Shoreline, and every scrutiny panel hearing up until my proposition, which was debated last September, have broadly been ignored by the Minister. So in fairness to my constituents I've been working with for over 3 years, in fairness to the public who wish to know where they stand, in fairness to the Jersey Complaints Panel who give their time for nothing in an attempt to better public service, in fairness to the officers who have to try and hold the Minister's line, and in fairness to states members who have to try to justify the situation to the public. In August last year, I lodged my previous proposition in an attempt to get some action from the Minister to bring clarity to the situation in the form of a clear, open and transparent policy, together with a map which sets out the public boundaries he is working to. Alas, that is not what we have in front of us today. For it was 3 days before my debate on 18th of September last year that the Minister published this cobbled together policy. And I say cobbled together not to be unkind, but as we have only got to read the recent scrutiny report that looked at his policy, and then the Minister's own amendment to his own policy, to appreciate just how utterly inadequate and lacking that policy was, and still is, in my opinion. The Minister tries to give the impression that the majority of scrutiny recommendations are being accepted, no doubt as a bit of a sop to states members to vote with him. But look again at his responses to scrutiny's report. Little is accepted, little actions are forthcoming. There is much agreed in principle, together with offers of possible delivery times of some time in the future. I remind members that the Minister has had years to produce this work, years to produce a coherent policy, years to produce a map, and we still don't have it. Just look at the Hansard transcripts, which I circulated to states members this morning, where I was asking the then Minister to produce a policy and a map. The date was September 2017. Over 3 years ago. So he has also had years to demonstrate how the generosity of the Crown's gift is going to be utilised in the way it was intended. And that is, and I quote from the deed of transfer, to encourage and research marine renewable energy projects. Instead, he pursues this immoral money grab embarrassment we are witnessing. Where is his request for £250,000 to resource and set up the work on renewable energy? Instead of £250,000, he is suggesting in his proposition, which he needs to pursue people for encroachments, the same encroachments that were granted planning permissions. Sir, I also wish to address some assumptions that have transpired during this issue. The most disturbing is that people who have properties which the department deems to have encroached the foreshore have knowingly and improperly done so. States members who attended my briefing on Friday can make their own minds up about that, as they were given the opportunity to hear from my constituents. Details of their cases are anyway well documented in the Jersey Complaints Board findings. The other assumption is in the Minister's own policy, and that is his default position seems to be that encroached land should be sold off piecemeal to anyone who occupies it. Is that what we want? Where is the ministerial decision or States Assembly decision saying we ought to be selling off parcels of the foreshore just because it has been encroached? It might be right in some cases, but certainly not all. To extract optimum benefit does not entitle the minister to sell off the family silver. The optimum benefit to the public might not always be in financial terms. It might actually be amenity space, which the public could actually benefit from in a more practical way. Sir, I have presented a policy that is fair, open and transparent and brings long-awaited clarity to this situation. My policy offers a date to define what is historic or a recent encroachment. It offers ways of dealing with them. My policy acknowledges historical encroachments which came about while the state arguably encouraged them with planning permissions and turned a blind eye for years. It also acknowledges that upon receipt of the gift and where the deed specified, and I quote, any right of access or exploitation exercised as a matter of long-standing custom should remain unaffected by the transfer. Yet the minister is now seemingly seeking to reverse this agreement and cash in. That is immoral in my book. My policy defines the foreshore. It also acknowledges that the minister already has the power to maintain the seawall and flood defences in the existing drainage laws. And my policy requires a map that sets out what is publicly owned land. It is a policy that the department should have brought forward years ago. Sir, I make my amendment.
How much is the amendment seconded?
Yes, sir.
There's an amendment to the amendment lodged by the Minister for Infrastructure, and I ask the greffier to read that amendment.
Page 2, paragraph A, and the proposed new paragraph B after the words Minister for Infrastructure, delete the remaining words and substitute the words to report back to the scrutiny panel with its proposals for setting out in a map or plan the public boundary.
Minister.
Thank you, sir. And I did begin by saying I wouldn't want a rerun of the original debate, and I'm afraid that's exactly what we've just heard. So I will go through the Deputy's amendments one by one, but if I could start by saying that overall I'm somewhat surprised as how the Deputy has approached this. In her proposition P101 2020, the Deputy put forward various arguments as to why the states should not treat the majority of foreshore encroachments as encroachments and should gift the land to the respective third parties. However, the Deputy, in drafting her amended version of the policy, appears to stop short of that and proposes that most encroachments be addressed through license agreements. Whilst licenses can be useful in some situations, they do not give the third party any form of ownership of the land or medium long-term security. I'm concerned, therefore, that such a policy would be detrimental to future transactions of coastal properties, as buyers will be very concerned at the prospect of part of their purchases being subject only to informal license.
Minister, can I interrupt you for a moment? At the moment, perhaps the position has been misunderstood. You're not required to speak on the Deputy's amendment, but merely to propose your own amendment to that amendment. Obviously, you'll have the opportunity for a speech on the Deputy's amendment when that falls to be debated as amended or not by your own amendment.
Yes.
I didn't wish you to be in a position to have to make the same speech twice.
Okay, so I will just make the note, sir, that I'm obliged to sell land. I cannot give it away. That would be illegal. I'm obliged by States of Jersey to sell land. If I give it away, I'll be prosecuted. Planning permission does not mean that you have good title to the land, doesn't mean you own the land. And as for extracting money, we're not extracting money at all. We're actually selling the land.
I mean, I'm sorry, but I'm required to ensure that we're not led down the wrong path in terms of the debate. And please forgive me if I'm misunderstanding. You appear to be addressing a number of the points made by the Deputy of Grouville in her speech. You will have the opportunity to do that when there is a debate on the amendment that she's proposed. At the moment, you're simply needing to propose why your amendment, adding those few words relating to a map or a plan, should be attached to her amendment, and you'll have a more general ability to say what you'd like about the Deputy of Grouville's amendment once that part has been resolved by the Assembly. I hope I'm not knocking you off your course, but it seems to me you're making general points in a speech that you would wish to make when one comes to discuss the Deputy of Grouville's amendment.
Asa, regarding yes. Okay, so I just make the amendment, sir.
So you would like you're simply proposing your amendment, which is to deal with the reporting back to the scrutiny panel with proposals setting out on a map or plan the public boundary.
Indeed, sir.
Very well. And did you wish to say anything about that specific amendment?
That'll do for now, sir. I'll come back to that.
Thank you very much indeed. Is that seconded?
Yes, sir.
Very well. Does any member wish to speak on that amendment alone? Connétable or St-Brelade?
Thank you, sir. Yes, just to speak in support of the amendment to the amendment, in that it really is, in my view, a no-brainer, in that the Minister is offering principally what is asked for in the way of a map, which is really fundamental to the whole discussion. So that is simply all I have to say on the matter at this point, sir. Thank you.
Very much. Connétable, Deputy of Grouville. Deputy of Grouville.
Yeah. Yes. Sorry, sir. I think what the Minister, far be it from me to put words into his mouth, but what he is actually proposing is that he does not have to produce a map at this time. And I am saying in my policy that the map goes hand in hand with a policy, so people know where they stand. We heard all the declarations at the beginning of this debate, sir, some of whom couldn't decide whether they were conflicted because they didn't actually know whether their land encroached upon the foreshore. Yet we have a department that's going to go around charging people for the use of this land. So what I'm asking for is a map. I think that is fundamental. And in the minister's proposition, his own proposition, he talks about master schedules that would be, and I quote, inappropriate to openly publish. It talks about a default boundary line, setting out public land, which it refuses to make public. How can it not be made public if this is public land we are talking of? There is a public registry of land, so how can the minister not publish his default position? Instead, he argues that property owners have got to go cap in hand to his department to justify their position from his secret master schedule and his secret default boundary deemed by public servants in a public department, but the map or plan they are working to will not be made public. It's a nonsense. For the minister, it is the minister who has so far adopted a very hardline approach against people, expecting them to produce, in some cases, receipts and documents for alleged encroachments that they might or might not have been responsible for. So I'm afraid I'm taking a hardline approach too, because he can't have it both ways. In his own revised policy, he states that clearly a map will be important. Well, Minister, I agree. So let's have a map, please.
Deputy Tadier.
Thank you, sir. It's an interesting situation we have, isn't it, where we've got two ministers who are at loggerheads, and it's a shame that this couldn't have been resolved around the ministerial table, because it sounds like the Minister for External Relations, that's not her title, something similar to that, isn't it?
International Development.
International Development. I always get the two muddled up, so because they're such similar titles. It seems to not have confidence in the Minister for Infrastructure, if that's still his title. So that's the first thing to observe. And she's effectively saying she doesn't support the government's approach on this. Again, which is an observation I think needs to be made, which would be fine if she was an opposition member, of course, but she's not. That said, we do have to look at the amendment and the amendment to the amendment on their merit. And I can see, I think on the very narrow issue of the map, it sounds reasonable initially to suggest there should be a map, but I do think, to be fair to the Minister, he does have to be mindful of privacy, confidentiality, the sensitivities around this, for exactly the same reason, in fact, that the Deputy of Gruville has pointed out, that a lot of these things will be subject to challenge. And so by simply producing a map, first of all, that doesn't necessarily resolve the issues, but it could be inflammatory if a map is made public, which isn't simply something which shows the public land, but it also, by showing the realms of the public domain, it necessarily will also have to show the areas of privately owned land and presumably the contested areas, which could be, as I've said, still subject to challenge. Those would be publicly available. And I was just thinking, if this wasn't to do with land, but it was to do with a different dispute that was going on between government and individual citizens, how would we feel if a list was effectively produced of all the properties, or all those taxpayers, all those citizens, and their particular disputes they were having? I mean, would we ask for a list to be published of all people from income support who have had an overpayment or an underpayment made to them, so that we can all decide who they are, and we can all chip in as members of the public to say whether we think that they've been treated correctly or not? I think that the considerations that the Minister puts forward, although on first glance the Deputy of Gruville's position might seem the right one, when you examine it in more detail, I do have a lot of sympathy for where the Minister is coming from. So I think he's doing it for the correct reasons. It's important to treat these issues sensitively, and I think publishing a map, for example, may not be the correct way to do that.
Thank you very much. Does any other member wish to speak on the Minister's amendment? No other member wishes to speak? Then I call on the Minister to respond.
Thank you, sir. And I'm very obliged to the Constable St Bernard and indeed the Deputy Tadier for their precise and concise notes, sir. So we're not out to get anybody, we're not out to rob anybody, we're trying to fix an age-old problem. Any money that's taken from sales of land goes to Treasury. It doesn't come to infrastructure at all, or property holdings. It goes to Treasury. So, you know, the old adage that I'm jumping up and down, rubbing my hands with glee, nothing going further from the truth. And the fact somebody has planning permission does not mean they have title to the land. And I agree fully, that is something that needs tightening up. And that's something I need to take up with our colleague, the Minister for the Environment, but to make sure that that is really firmed up so we don't have any of these problems in the future. I think it's been a very pragmatic approach that we've taken, that if we adopted the Deputy of Grouville's amendment, then it would be very, very dangerous. In fact, that nobody would have title to the land. Often as not, people come to Jersey Property Holdings, not the other way around. Normally it happens when somebody's out to buy a house, and as they're about to buy a house, obviously they employ a solicitor, a lawyer, and the lawyer will point out, well, there's a problem here, this land isn't yours. You need to sort this out because it's not in the deeds. And that's when Jersey Property Holdings and the law officers come into play, that we try do our best to sort it out pragmatically. No one's being robbed, no one's being charged, no one's being fined. The pragmatic approach is they are sold the land that they occupy. So it's a win-win situation for them. There are occasions where it will be licensed, as we found in the past, that we've had several breaches of the seawall, and my team were doing their best to fix those as soon as they occur. But I'll say no more on this, sir. I make the amendment, sir.
Thank you very much. I'd ask the greffier to place a voting link into the channel. The link has been posted. I open the voting and ask members to vote in the normal way. The vote is for or against the Minister's amendment to the amendment of the Deputy of Grouville. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting.
Sir.
Yes, Deputy Grouville.
I didn't receive a voting notice.
It was in the it arrived in the chat, but you've indicated your vote in the chat, so we will accept that.
Have you received that?
Yes.
Right. Okay. Thank you.
Well, voting is closed. The amendment has been adopted. 23 votes pour, 17 votes contre, no abstentions in the link, and 1 vote pour and 1 vote contre in the chat. Very well. We now return to the debate on the Deputy of Grouville's amendment. And Does any member wish to speak on that amendment? Does any member wish to speak? Conrad of St John.
Thank you, sir. So this is an excellent amendment by the Deputy of Grouville, and having attended the hearing, the presentation on Friday, it was clear that this is the correct approach. It is not for government to bully and push people into a position which they are unhappy with. This is, I believe, the correct way of going about it, and I would urge members to support the Deputy of Grouville's amendment. Thank you, sir.
Very much, Deputy Young.
Thank you, sir. I wasn't planning to speak, but I feel there's a couple of points I think I need to make. I listened to the arguments carefully. I find the whole business pretty unpleasant, really. There was a gift, and I know very well that in the past there have been people who have made transgressions, some of them deliberate, probably most of them accidental, and of course with a coastline you're dealing with a movable feast. And I think the points that Deputy Labby made were very well made indeed. I really feel very, very uncomfortable with the history of disregarding a complaints board. The complaints board have obviously looked at this very, very carefully, and they've produced a report. I'm not familiar with all the issues, but I obviously have got the bottom line of what they've said, and I feel very uncomfortable with what I think is potentially a Big Brother approach. It's not the way you do things. It's not in accordance with Jersey's culture. Now, I'm disappointed that we now have an amendment which effectively means that we won't be seeing a comprehensive map. I think it's clear. I cannot see any way in which we can help people to be able to make judgments and know where they are, unless such a thing is there. Now, I understand what Deputy Sadier says. We've got a situation here with ministers having a different view, but I think there are moral issues here, and so I feel now, because the amendment of the infrastructure minister has now been approved, we won't be having a map, and I think it's going to be very, very difficult to have a policy which is clear and achieves all the sort of criteria that spoke. I do need to flag up one thing. I noticed that my colleague said that he needed to talk to the Environment Minister about sorting out boundaries on planning applications. Well, I have to be very, very, very clear. Planning consents do not entitle people to do things. They need to have proper title to the land to do that. For example, one could get it. There's nothing to stop people putting in planning applications for land they don't have title. It happens all the time, but they cannot execute it or implementing it unless they have a legal right to do so. There is absolutely no way the planning system can guarantee land ownership. One relies upon the certificates that people give in making planning applications. But it is true that from time to time transgressions do occur. They don't only occur on shorelines. In fact, the majority don't. Most of them occur on boundaries. So please, I think whatever vote, I just want it to be clear that the planning system cannot resolve property ownership. It deals with permission and entitlement. If you have the legal rights, then you can do things. It's a matter of private law. I wanted to clear that up, sir. So I think I will be supporting my fellow minister of Deputy Labby of Grouville. I think on balance, I just feel very uncomfortable with the whole thing, frankly. Thank you, sir. Very much.
Does any other member wish to speak on the amendment of the Deputy of Grouville? Conatarbus and Brillard.
Thank you, sir. I'm going to speak in fairly general terms because the Deputy of Greville wraps the whole matter up in her amendment. So in 2015, the foreshore was gifted from the Crown to the public of Jersey, and since the time of transfer, Jersey Property Holdings, under the ministerial remit of the Minister for Infrastructure, has sought encroachment compensation payments from a number of property owners along the foreshore. And this there is quite crucial. The sale of a property has typically been the trigger point for collection of these payments. And that word trigger point is once again seems to me to be quite fundamental. And this there is in addition to the planning consent applications or an approach made by a property owner to JPH, and the Minister of Environment has just spoken in regard to that process. In late 2017, complaints regarding the current policy and handling of encroachments of the foreshore came to light. Thereafter, the proposition P101 was lodged in August 2020 by the Deputy of Greville, as she's previously referred to, requesting that a revised policy be brought forward for debate by January 21. Subsequently, the Minister of Infrastructure lodged his amendment to P101, and timing was tight, sir, but although the Minister for Infrastructure largely dismissed the findings of the Complaints Board, it was agreed that a review of the policy would be undertaken to reassess the foreshore encroachment policies, and a revised policy would be issued subject to the outcome of the review. So, sir, a review of the current policy was undertaken by the Minister for Infrastructure over the last 2 years, and the proposition P111, which we are debating today, is in front of us. So I think that is enough to explain that, as others have mentioned, it is not straightforward and has been very convoluted. In consideration of numerous emerging key issues and concerns regarding this proposition on the table today, so the panel agreed, this is my Housing, Environment and Infrastructure Scrutiny panel, agreed to undertake a review of the revised policy. The panel focuses its terms of reference on these primary issues, with particular emphasis on the history of the ownership of the foreshore and the issues regarding the definition of its boundary, the establishment of the foreshore boundary, the impact of current encroachments on Jersey sea defences and on the maintenance of them, the approach used to seek compensation payments for encroachments, and whether the revised policy is deemed fair, proportionate and fit for purpose. The panel, sir, sought to gain a better understanding of what was meant by the foreshore, its boundary and the encroachments of it. The review found, sir, that there is much discrepancy surrounding this issue, particularly the definition of the foreshore's boundaries. The panel found that the foreshore is a movable concept that is impacted by various factors, including the changing high water mark, and moreover, its uncertainty is amplified due to the structures, including seawalls, and the action of reclaiming land over the years. And I might put in, sir, that it may have been better to consider at the outset using chart datum such as nautical people do, because it's a much more precise point, but that's something for future discussion. Concerning the ownership of the foreshore, so the panel observed a recurring theme throughout the submissions of ambiguity regarding the foreshore land that was initially Crown owned. The review found that it is disputed that all the foreshore land was indeed Crown owned to begin with, and therefore couldn't all have been gifted to the public by the Crown in 2015. Evidence gathered indicates sustained uncertainty over what land was Crown owned land. This uncertainty of the boundary line is concerning to the panel, particularly as the boundary line would be pertinent to any revised policy in understanding of whether an encroachment of the foreshore had occurred or would occur in the future. When considering alleged encroachments of the foreshore and how an encroachment is defined, the review found that whilst open to legal interpretation, a recurring view that Clause 2 of the deed of transfer from the Crown to the public implies that any long-standing, habitual and recognised custom by the general public should remain unaffected by the transfer of ownership. The panel found that it is deemed by many that seeking compensation payments for encroachments on what was previously Crown-owned land would not be in keeping with the spirit of the contract. The panel has recommended the Minister for Infrastructure should give further consideration to how encroachments are dealt with in relation to those that predate the gifting of the foreshore from the Crown in 2015. And specifically, this should consider whether the land in question was Crown-owned land to begin with, and a date determined from when alleged encroachments should be considered. The panel noted that this should be considered prior to the adoption of the revised policy. And I note so that the Minister, if we get to his second amendment, has agreed to that. As part of the Minister for Infrastructure's review of the current policy, a review of the land side boundary was undertaken by the Law Officers Department. The panel found that the master schedule being compiled to capture all key data, including the extent of encroachments around the island and a possible resolution. Although a master schedule of encroachments has been provided in the confidence of the panel, there is currently no map showing a definitive boundary line or justification provided to the public as to how this has been determined. Moreover, so the review found that the master schedule would not be made publicly available, and the panel observed a notable lack of transparency over where the boundary is and how it has been determined. The panel has recommended, in the interest of greater clarity and transparency, that the Minister should consider further how the boundary line of the foreshore and the basis of evidence for its determination can be made publicly available. And once again, so the Minister has conceded to do that in his latest amendment to the amendment. The panel observed that a primary aspect of the Minister for Infrastructure's review of the current policy was to ensure that essential maintenance of sea defences was possible and not inhibited by any encroachment. The review found that there was insufficient evidence to suggest that encroachments along the foreshore had significantly affected the Minister's ability to maintain sea defences. Additionally, that other policy mechanisms could be explored to ensure that maintenance and upkeep of sea defences is not compromised. Therefore, the panel questioned whether the revised policy was required to seek compensation payments in the manner it intended. The panel has recommended that the Minister for Infrastructure should consider a separate sea defences maintenance policy in addition to how planning obligation agreements might satisfactorily be utilised going forward to ensure adequate upkeep and maintenance of sea walls where encroachments are concerned. And so the Minister has conceded to look further into that. In relation to the seeking of compensation payments for encroachments, through evidence gathered via meetings and written submissions from members of the public, the panel observed a recurring view regarding concerns of the handling of foreshore encroachments and the current policy. The recurring view is that the approach in which the current policy was being applied was unfair and discriminatory. The review found that conveyancers and lawyers would be aware of the issues and possible ramifications relating to the difficulty in determining the foreshore boundary when an adjoining property is sold, and would draw this to the attention of the prospective purchasers during the conveyancing process. Additionally, that property owners seeking planning permission have a legal duty to declare ownership of the land they are seeking planning permission for. Notwithstanding this, the panel found that in some cases planning approval had been granted where it had been already acknowledged that encroachments either may exist or are likely to be incurred. Furthermore, that prior to the transfer of ownership from the Crown to the Public of Jersey, when requests were made for works which would incur on an encroachment under its ownership, the Crown generally acquiesced to these requests. In these instances, property owners have still been required to pay compensation payments for those encroachments. The panel has recommended so that the Minister should, in collaboration with the Minister for Environment, seek to put in place a suitable formal protocol for dealing with permission applications relating to properties along the foreshore. The Environment Minister alluded to his views earlier. Additionally, the Minister should seek to apply the policy in a fair and non-discriminatory manner, and not solely to those where a trigger event when either the property is transacted, planning permission sought, or a direct made to dirty property holdings by a property owner has occurred. Compensation sought or paid should be reflective of the encroachment and limitations agreed. Moreover, so the panel has recommended that this should be reflected in the revised policy prior to its adoption. And I think the Minister concedes to that. During its review, the panel sought to gain a better understanding regarding whether a varied approach would be undertaken to resolve deliberate as opposed to unintentional encroachments. The review found that there appears to be no clear differentiation between how a deliberate or unintentional encroachment on the foreshore would be dealt with. The panel has recommended the Minister should seek to differentiate between a deliberate or unintentional encroachment in the revised policy, and this should be incorporated prior to its adoption. Now, I'm aware, so the Minister is not so enthusiastic about that recommendation, in that his suggestion, and I'm sure he'll cover that, is that the court processes are, well, the courts are better placed to deal with that situation. The panel also found the sliding scale had been previously applied to determine the level of a foreshore encroachment payment, and that the sliding scale mechanism would continue. However, the review found that the criteria for the sliding scale is not included in the current or revised policy. The panel has recommended the Minister should further define and set out the criteria for this sliding scale into the policy so that it is clear and transparent, and this should be incorporated prior to its adoption. The review found that much emphasis had been placed on the intention for each encroachment to be considered on its own merit. However, we do question what process is in place to ensure this will occur as intended. We found, sir, that there is a lack of information contained in the revised policy as to how the approach will be taken to judge each case by its own merits, and what processes will be in place to ensure this happens. We have recommended, so that the Minister should be explicit in the revised policy as to how each case will be considered on an individual basis, and what processes will be in place to ensure this happens. And this, once again, should be incorporated into the policy before its adoption. I believe the Minister has acquiesced to that. Observing the development of the revised policy might have impacted upon property transactions, and we sought to gain an understanding of the degree of impact the policy development process has had on individuals wishing to sell properties adjoining the foreshore. We found that some degree of impact had been felt in relation to transactions being delayed due to the policy development process for the revised policy, although the actual scale of this impact is uncertain. It is, however, conceivable that the length of time and approach taken is likely to significantly impact some property owners along the foreshore. And when considering previous complaints, procedures, evidence to the panel, and the extensive time taken to arrive at any form of resolution, we raised concern regarding the complaints or appeals process that would be in place regarding the revised policy. The review found that there is currently no suitable complaints or appeals mechanism provided for in either the current or the revised policy to satisfactorily enable individuals to appeal a decision made by the Minister in relation to foreshore encroachment compensation. The only option available to individuals is to make a case to the Jersey Complaints Board. This is particularly concerning to the panel, and consequently the panel has recommended that the Minister should seek to incorporate a suitable and workable process for dealing with complaints relating to foreshore encroachment compensation payments, and in addition a clear appeals and arbitration process for dealing with any such complaints. This should certainly be incorporated into the policy before its adoption. In consideration of all the evidence gathered, sir, to determine whether the revised policy is fair, proportionate and fit for purpose, the review found an overwhelming and unanimous view that the revised policy remains an unfair approach. Moreover, that it is complicated, unclear and lacks transparency. So on the 31st of December, the Deputy of Grouville lodged her amendment, and the accompanying report highlights the revised policy remains ambiguous, confusing and open to interpretation and would not provide comfort to the public. The Minister seems to have failed to give credence to the views or concerns that might have been expressed by States members as the revised policy was lodged 3 days prior to the September debate of P101. It highlights the disregard of the views and findings of the Jersey Complaints Panel, and in her accompanying report, the Deputy Greville highlights that although the public was entitled to establish a different policy towards encroachments, it should...
Sorry, Conrad, the bell has gone.
Right. I shall conclude that.
Well, thank you very much indeed. Yes. And we've got Deputy Lewis.
Thank you, sir. And I think it's unfortunate. I don't believe that the Minister for the Environment, Deputy Young, was at my briefing, or he would have heard everything that was discussed there. But in his second batch of comments, I agree absolutely. The fact that one has planning permission does not mean that you have title to the land, which is something that obviously we are trying to sort out now. And I've sought to address the matter of a map and its publication in my own amendment. Basically, we need more time to do it, to put the map together, and we think it could be a breach of human rights if we published it. We're not into naming and shaming anyone, because we would like the people who believe they may be encroaching to approach the departments, and we will sort it out on a confidential basis. I will leave it there, sir, and I urge members to reject this amendment, sir. Thank you.
Much. Does any other member wish to speak on the Deputy of Greville's amendment? Chief Minister.
So can I just check a point of clarification for you, just in case I've missed the point here? We are on the main amendment here, sir, aren't we?
We're on the Deputy of Greville's amendment to the Minister's proposition.
Yes, sir, exactly. So
if this is passed, then the Minister's proposition will be amended in accordance with the Deputy of Greville's amendment. If it's passed, then the Minister's second amendment. Sorry, has that clarified sufficiently for you?
Well, it does from my perspective, so thank you. So I just wanted to, I think, make a few points in generic terms and just explain, sir, why this is important, why it's complicated, and equally so why I'm hopefully that'll then outline the issues in terms of going forward. And I do note the comments that have come through from scrutiny, but I think we just need to go back to the fundamental point. And I have been involved actually, sir, for a number of times, for a number of years on this. In fact, I think in the original time when we had a briefing, sir, it quoted something, a decision I'd made when I was at Property Holdings back in 2006. And so the issue around value, which I think is important, sir, is that the states as a landowner has various rights, wears various hats, as it were. And one is in the capacity of, as a, if you like, land owned, when not owned by the public, sir, used, for example, on pavements or on roadways particularly. And there are also land where owned land effectively as a private landowner. And one of the moral discussions that comes through, sir, which is sometimes difficult to grapple with, but is ultimately going down a very tried and tested route, is if one gives land and access across land, and let's say it's to a developer, sir, if the granting of that access to the developer enables that developer to obviously build a property or properties, and for the sake of argument generates £1 million profit for that developer, is it unreasonable for the landowner to therefore charge that developer who's doing this for profit and generally a relatively small sum, but a sum of money, sometimes relative to the amount of profit that will be charged, for their own benefit? Or in this instance, if we're holding land on behalf of the taxpayer, sir, but in a capacity as a private landowner, ultimately for the benefit of the taxpayer. Because if not, if that is wrong, sir, then there's an awful lot of places around the world which are also doing it wrong. And I use that analogy. I definitely recall in my time in Property Holdings where landowners and councils in the UK and all those type of things had what was sometimes strips of land which controlled that sort of access. And it is absolutely accepted, including by the RICS, the Royal Institute of Chartered Surveyors, and other general property valuation entities. It is absolutely standard practice that one charges an appropriate value for access across land which does not belong to the person who needs that access. And I think that's the fundamental one. That's something that we've got to deal with. The other one, sir, is it's about having immediate access to land in an emergency. And I do know, sir, that what used to be called TTS, now IHE, or previously many years ago, Public Services or the Public Works Department, has for many years had issues around access to seawalls, to culverts for future maintenance. And sometimes that can be needed in an emergency in the middle of the night because of flooding, particularly, or damage to drains or whatever it is. And that is why having control over that land and being able to then set over a long period of time. This is the other thing to remember in terms of land. So it is there generally forever. And so even though one might not need access in 10 or 20 years time, in 40 years time, one might well need it. And the legal title is important. And so, and that's particularly germane in these circumstances, for things like seawalls and sea defences. And because water doesn't respect boundaries. So if we had a row of 10 houses where 9 of them have remained and have respected for example, the setback from behind the seawall to allow access to that for repairs and maintenance, but one has not, or one has in some shape or form through historic measures managed to encroach to the seawall or acquire the seawall or build on the seawall, but then doesn't maintain it. If that seawall is breached at that point, it will then threaten not only just that one house, it will threaten all of the houses. And indeed, so that was drawn home to me very, very pertinently in the last, I think, 3 weeks, when I received a phone call from an individual representing residents in a particular property who potentially would have had to be evacuated that night because the property actually was built on top of the seawall and the seawall was in danger of crumbling. And whilst there are specific and probably complicated circumstances there, it brought home to the fact that under the, I think it's called the Foreshore Management Plan, sir, over the next, and frankly, 100 to 200 years, but equally starting in the next 20 to 30 years, as global warming comes through, and as we have to maintain and increase sea defences, there will be actions that the states will need to take, maybe in our political times, maybe in our lifetimes, certainly, and also beyond, to protect the wider interests of islanders, but which will therefore require issues surrounding individual land owners. And particularly, therefore, sir, that is why one needs a policy, which, as I understand matters, has been done very clearly in conjunction with the law officers, with the Attorney General and the Solicitor General, who are very clear as to why this is needed and why it is appropriate. And so, sir, I think the issue for me, simplistically, in looking at the some of the wording from the Deputy Gruville, and I have said in the past, sir, I absolutely commend her tenacity on this matter. She has been fundamentally trying to support her constituents, and I absolutely agree and commend her on that. And it's very difficult because I do very much like her and her tenacity on this area, but I unfortunately don't agree with the stance that has been taken on this. And I think one of the things in terms of looking at her amendment, it does make life more difficult for what is referred to as the historic encroachments, as I understand matters. That's certainly the advice I believe that we have received. And I think that difficulty then lays out problems going forward for the public of the island, particularly in the context of having to manage the sea defences and global warming. And what is also very, very clear with the difficulties of encroachments before and after a particular date is, I think it was January or February last year, so I walked from the Royal Jersey Golf Club, all the way around, I think, to Green Island, to look at all of the individual encroachments there. And there are some where it would always be difficult and what have you, and there are some that are blindingly obvious that there has been an encroachment And that is why, sir, each individual case needs to be considered on its each individual merits. But that is why overall there has to be a policy in place. I think the ministers ably described it, particularly at the briefing last Thursday, and very much I commend and support him and his officers behind the work they're trying to do. But the fundamental principles for me, sir, are that value on this is appropriate, access to it is appropriate from the point of view of dealing with global warming, and public access to land, particularly in an emergency, and that can be hopefully not, but during storms, it can be immediately the day after storms. One does not have time to then work out the legal niceties of whose land is it and all that goes with that, because generally at that point people's properties are being damaged and potentially, hopefully in extreme exaggerations, at the real extreme, people's lives do get put at risk at this. So and of course individuals do get very excited on these subjects, particularly if they are the ones who perhaps have been badly advised by their legal advisors and not been made aware of potential encroachments that previously existed. The issue of Crown land is that there is not what we call the 40-year rule. So as I understand matters, land and encroachment on there is essentially you can't steal land from the king, from want of a better expression. That's me as a layman using that expression, and therefore that the clock does not start ticking on the 40-year rule, and it did start ticking when the land was transferred across. So encroachments are there, they do need to be resolved. This is a policy that's had a lot of work put into it, particularly an officer who I think effectively walked around the entire island dealing with and identifying all of the encroachments that have taken place, and that is why it has taken a long time to get to this point. I'm going to stop there, sir, because there is an awful lot of complexity, but with regret, sir, I will not be supporting the Deputy's proposition. Sir, is it appropriate for me to be asking a question of the Attorney General or not, sir?
Yes, you're entitled to ask a question of the Attorney General, Chief Minister, if it relates to the amendment, of course.
Well, actually, so the generic one is essentially, can you just confirm that what I've just said, that title over Crown land does not, that when there's an encroachment on Crown land, the 40 years rule does not apply, and then obviously, but it does start applying that when title is changed to the public in this instance, and whether it is acceptable from a legal perspective for value to be obtained from an encroachment over land.
Mr. Attorney, are you able to assist the Assembly in answering that question?
So yes, I am. So in relation to the first part of the Chief Minister's question, yes, he's correct that as against the Crown, prescription does not run. So our 40-year rule of prescription in relation to land doesn't run against the Crown, but it did start running against the Crown in 2015 when the Crown ceded and transferred its interest in the foreshore, say for the Ecrahos and the Minkies, to the public of the island. In relation to the second part of the Chief Minister's question concerning is it appropriate for value to be sought in relation to a public asset? Well, sir, that's a policy matter, I suppose, but in legal terms, it certainly is. It's a fairly long-standing principle that has been adopted by the states certainly since 2005, 2006, and it's been a policy that has been followed when the foreshore was owned by the Crown, and the Minister's amendment, I think, sets out an appendix examples of 10 or 12 contracts where there has been consideration paid when the foreshore was in the ownership of the Crown. And on that principle, there is a case that is fairly recent, which doesn't concern the foreshore, but the principle is of relevance, and that is the case of Fogarty. And in that case, it was concerned with an encroachment as between neighbours, not on the foreshore. and an issue was whether it was appropriate for an encroachment on one neighbour's land to be removed. And the court found that whilst there is that jurisdiction, there is also an equitable jurisdiction to award damages in lieu of requiring the interfering encroachment to be removed. And the court considered human rights arguments, in particular the right to family and home life under Article 8 of the ECHR, and also Article 1 of Protocol 1, the right to property. And the court considered that just requiring an interfering encroachment to be removed was potentially inconsistent, and was inconsistent with the ECHR, and that an alternative equitable jurisdiction to award damages was far more consistent with ECHR principles. So that is why the Minister's version of the policy keeps in the alternative remedy of seeking a payment from the party who has the interfering encroachment. Whereas in Deputy Labby's version of the policy, that is absent. So there would not be that alternative of seeking a payment. There is only, in Deputy Labby's version of the policy, there is removal, or there's allowing it to remain or having a license. There is no option of keeping the encroachment, but requiring the party to pay consideration for allowing the encroachment to be kept. So that is why the Minister's version of the policy is wider. It also allows title encroachments to be dealt with, because there are instances where properties have claimed ownership of the foreshore in their title deeds, but the Crown or the public of the island was not a party to those contracts, so its position, its consent has not been obtained. So therefore, that's why the Minister's version of the policy also seeks to keep in a remedy in respect of title encroachments, which is not present in Deputy Labby's version of the policy. So I hope that answers the Chief Minister's questions.
Sir, Polly, can I ask just a clarification?
Yes, indeed. Yes.
I was listening very intently, and it was the very last bit that the Attorney General referred to, which I think would be helpful if you just, well, have I understood it properly, which I think I have, which is basically the purpose, the wording of the present amendment that we're debating versus the Minister's proposition is that essentially it isn't sufficient broad enough to give flexibility to the Minister to deal with all the likely circumstances that could arise with encroachments, and therefore one could end up in the position where the Minister wouldn't be allowed to negotiate or price or something for an encroachment. It would basically have to be removed, i.e. that it would tie the hands of the Minister from dealing with individual circumstances. Have I understood that correctly? Or perhaps if I haven't, could you perhaps just clarify that?
So yes, that's correct. The Deputy Labby's version of the policy does not have the alternative option of a payment, or the alternative option of dealing with title encroachments, or the alternative option of agreeing a boundary line. So all of those options are not available under Deputy Labby's version of the policy, whereas they are available under the Minister's version of the policy.
Okay, thank you, sir. That's definitely concluded my position on the speeches, and that is also why, sir, I am not supporting the amendment. Thank you, sir.
Any other member wish to speak on the Deputy of Grouville's amendment? No other member wishes to speak on that amendment. Deputy Swan. Deputy Simon.
So thank you. I would like to make the point as somebody who has practiced as a lawyer in this area in a previous life, that the problems and complexity associated with foreshore was well known to lawyers who were engaged in conveyancing work. Of course, we would warn clients who were buying a property adjacent to the foreshore about the problems and the sometimes indistinct boundary, because the property deeds would not record a precise boundary in terms of measurements. They would generally simply say, and bordering on the south or east or west, the rivage de la mer, or the seashore, and quite where the seashore might have been before a sea wall had been built was open to question. So therefore, it was important for clients thinking of buying a property to make a decision. Would they want that clarified by the Crown at the time? Or was the building that they were buying sufficiently far from the sea wall that they didn't think there was a risk, and it was clear that the public still enjoyed its rights over land behind the sea wall? So in many cases, well, not necessarily in many cases, but on occasions, the Crown was approached to reach some sort of agreement. And I wish really to make that point, that it's not the case that the Crown acquiesced in allowing people to encroach upon the foreshore. In fact, the experience of lawyers was that the Crown was often astute to assert its rights of ownership and prevent blatant encroachments on what it considered to be the foreshore. I don't agree with the view that might be expressed that the Crown had a rather laid-back attitude and was content for neighbouring properties to make use of the foreshore, because that was not always the case, and particularly where there was something that very blatantly had been constructed on the foreshore, perhaps to add value to private property using public land. The Crown quite rightly would have objected to that, or would have pointed out what had happened, and in appropriate cases would have acted accordingly, either to seek to remove encroachment or to seek a compensation for it, which reflected the value added to private land. And it seems to me that the Minister's policy accords with that question of maintaining public interest over private interests in land which was formerly the Crown's and which has now been given to the public. And it is important to have the distinction, to talk about the distinction that has recently been mentioned in speeches, that in dealing with the Crown, a lapse of time on the part of the Crown could never prevent the Crown reclaiming the foreshore or acting to remove encroachments. But now that the foreshore has moved into public ownership, time is of the essence. And though there is a prescription limit of 40 years, a long time in which claims can be made, nevertheless, the longer encroachments are left, the more difficult it is to secure a removal, to bring cases to court, to find sufficient evidence. So it is right that with that pressure of time, it is right that action is taken to deal with the most blatant encroachments that may exist or people may try to put onto public land. So I think it is absolutely correct that the Minister for Infrastructure should be proactive in this respect if encroachments are known about. He must ensure that land is not being taken for private purposes and accruing value to neighbouring landowners who would one day realise that value upon a sale possibly. It's right that the Minister for Infrastructure should also ensure continuing access for sea defence purposes and drainage works. And I find, sir, that contrasting these two alternative policies we have, this complex area, it appears to me that the Minister's policy ensures a greater flexibility, where it's sometimes appropriate to recover land that has been encroached upon and restore it to full public use, but on other times the encroachment can remain and either land be transferred, and that could be with or without a compensatory payment to the public, but it will depend on all the circumstances of the case. And sometimes encroachments can be permitted to continue on a license basis, such that it will allow the neighbouring owner still to have the benefit of an encroachment, but not prejudice the public's interest in the ownership of the land or the ability to act quickly to deal with sea defences and the like. So in this matter, sir, my view is that I don't see too great a difference between the previous Crown policy and the policy the Minister is now seeking to put forward, and I accordingly would be pleased to support the Minister's policy as the one with greater flexibility here. Thank you, sir. I'm grateful.
Thank you very much, Deputies. Any other member wish to speak on the amendment? Senator Moore.
Thank you, sir. Members will be pleased to know that I won't speak for long. However, I did feel it important to comment upon the previous speaker, who outlined that clearly there have been known difficulties and issues with this matter for a considerable number of years. And in reaching the conclusion that the Minister did just then, he expressed his view that it was right to support the Minister for Infrastructure on this matter. I take the very opposite view, sir, because we must also remember the views of the complaints panel and their findings, and I'm sure that the Deputy of Grouville will remind us of that when she sums up. In my view, the Deputy of Grouville should be applauded for representing her constituents in this way and for doing exactly what we are all here in this assembly to do, which is to represent the people of the island with common sense and with compassion, and to try to drive resolution to thorny issues in a reasonable and practical way. And I feel that she is doing exactly that, and will be supporting her vigorously when we move to the vote. Thank you, sir.
Very much, Senator. Does any other member wish to speak on the amendment? If no other member wishes to speak on the amendment, then I close the debate and call upon the Deputy of Grouville to respond.
Thank you, sir. I'd like to probably address Deputy Tadier's remarks that he made, which were a little unrelated to the actual debate, but nonetheless he made them. And I had toyed with the idea of saying something actually before I started my debate, and that this debate has undoubtedly put me in a difficult position with my colleagues on the Council of Ministers. and I regret that. And while I bring my amendment forward as the Deputy of Grouville, I am nonetheless a minister, and it is not the done thing to go up against another minister. However, I was not a minister when I took up the work on behalf of my constituents, and I was not going to give up on their call just because I became a minister. But to be clear, I've been put in this position because I have pursued this issue as I would, as I've just said. I wasn't going to give up on them, but I have pursued this issue. But I'm in this position, frankly, because of the extraordinary amount of time it has taken to get some action or any workable policy tabled and debated. So I hope that satisfies Deputy Tadier's curiosity into why a minister is doing this to another minister. But as Senator Moore has just reminded us, we're here to serve our constituents. There were a couple of remarks. Senator Le Fondre was speaking quite a bit about the rising tides and global warming. But as I reminded members in my opening remarks, that the Minister for Infrastructure has all the powers and the authority that he needs in the Drainage 2005 laws. So he has everything there in order to access, maintain, remove and clear so whatever he needs to give him the right to upkeep this his sea defences. I would as well, I'm afraid, disagree with the Attorney General. He drew some conclusions to say that my policy doesn't allow for any payment whatsoever. Well, I disagree with him, and I invite members to read my policy requiring interfering encroachments to be removed or subject to reasonable conditions as the Minister specifies in a licence agreement. So it's up to him what he puts in that licence agreement. It's up to him what he agrees. And that could very well include payment. I would like to thank everyone who attended my briefing last Friday. And I would also like to thank the GRAF for drawing up the two policies for ease of reference side by side and to enable members to compare them. Because I appreciate with all the amendments, it's not an easy thing to follow. But I'll go back to where I started in this debate, and I asked what we as States members seek in a policy. And that has surely got to be, a policy has got to be necessary, fair, open, transparent, and convey a clear message. I believe my policy offers all of those things. It is crystal clear and it's easy to understand, unlike the Minister's policy. My policy identifies 3 different scenarios and has clear rules for dealing with 3 types of encroachment. It allows for flexibility so that each case can be considered on its own merits, but within a clear and fixed parameter. And my policy honours the agreement that was made in the deed of transfer, gifting the foreshore, and yet seeks fairness to the public where the foreshore has been encroached. My policy was tabled after I recognised that the Minister's own long-awaited policy was so lacking and did not advance the situation one bit. Even his own amendments to his own policy renders it unfit for purpose and requires us to wait even longer for a resolve, as he has demonstrated in his responses to the scrutiny report. My policy offers the clarity of a date, what is deemed as historic or a recent encroachment, and seeks ways to define them. It defines the foreshore. It acknowledges the Minister already holds the power to maintain the sea and flood defences in the existing drainage laws, and it requires a map. Alas, at least the Minister admits in his own policy that a map is necessary. So I would like to make my amendment, and in so doing, I would urge members to think about voting with my clear, concise policy, which conveys clarity and brings resolve to this situation. Thank you, sir.
Thank you very much, Deputy. Now, Deputy Ward, you've asked for, firstly, Chief Minister, you have a question of the Speaker?
Sorry, all it was is the Deputy prepared to do her vote, a separate vote for Part A, which has been amended, and then a separate vote for the rest, sir, assuming that is practical?
It's open to it's entirely a matter for the mover of the amendment to determine how the vote is to be taken. It's not a matter in which members can ask. So, Deputy of Grouville, do you have any particular preference?
Well, the first vote is on policy, and the second vote is on the map. So I'm quite happy to take them separately.
Right. So the first vote then is going to be on paragraph A. Which is to approve a revised policy for encroachments on the foreshore as set out in the appendix to the report accompanying this proposition. And hopefully members have that. And then the second vote will be the question of the map, to request the Minister for Infrastructure provide a map. Well, that's been amended to request the Minister for Infrastructure to report back to the scrutiny panel with his proposals for setting out in a map or plan the public boundary. That's the amended proposition that the Assembly adopted earlier. So the answer is yes, it's possible to take paragraph A first, and we'll take paragraph A now, and I ask the greffier to put a vote into the link. And I open the voting and ask members to vote. This is the vote is on paragraph A to approve a revised policy for encroachments on the foreshore as set out in the appendix to the report accompanying this proposition. How many? Members have had the opportunity of casting their votes. I ask the greffier to close the voting. Paragraph A of the amendment has been adopted. 29 votes pour, 15 votes contre, 1 abstention in the link, and 1 vote each pour and contre in the chat. We now ask the greffier to post a second link to vote on paragraph B. Which requests the Minister to report back to the scrutiny panel with his proposals for setting out in a map or plan the public boundary. The link has been posted. I open the voting and ask members to vote in the normal way. Yeah. If members have had the opportunity of casting their votes, ask the referee to close the voting. The Part B of the amendment has been adopted. 39 votes pour, 2 votes contre, no abstention in the link, and a further 2 votes pour in the chat. Very well. As the Deputy of Grouville's amendment has been adopted, the second amendment from the Minister falls away, and we now move back to debating the Minister's proposition as amended. Does any member then wish to speak on the proposition as amended? If no member wishes to speak on the Conitabus and Brillard.
Thank you, sir. And it's really just a brief note that it's been suggested that some property owners have exploited the public of the island by developing their properties beyond the boundaries to which they have contractual right, whereas they may suggest that it's purely a result of lack of clarity in the definition of the foreshore and particularly the high water mark. So a contributing factor in determining this elusive foreshore is the extraordinary tidal range that we experience, added to by variations dictated by weather and atmospheric pressure. So we find ourselves in a juxtaposition whereby its position is largely defined by nature, but we have that those hard commercial considerations such as land and property values to consider. And I would just conclude by saying, sir, to those members who happen to look out of their windows at the foreshore this morning at 8:30 or last night to see the effect of a 38-foot tide and how far up the walls it did come is quite an eye-opener and actually could certainly serve to inform this debate. So I'm pleased that we are moving to a conclusion in a direction which may not be satisfactory at all, but will certainly be a move in the right direction. Thank you.
Very well. Does any other member wish to speak on the proposition as amended? Deputy Young.
Just to say briefly, sir, echoing the Conitab's comments. This is such a difficult and complicated issue. I trust where we've ended up, that we've ended up with something workable. The principles of the policies proposed, the amendment and a map, which is going to be extremely difficult, but there's no question in my mind we need a map, but I just cannot see that it will ever be a definitive map for all the reasons people have said, but I will go along and support where we finished up. What I am left with a feeling is, you know, whether this painful process was really worth it. Sorry, sir, that's how I feel.
Very much. Deputies, any other member wish to speak on the proposition as amended? No other member wishes to speak on the proposition as amended? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
Thank you, sir. And I thank everyone that's spoken. This is going to be very, very hard to put into place, sir. I think there were a lot of people who were confused regarding A and B. on the amendment, but well, we are where we are. Regrettably, not every encroachment can be resolved amicably. It's therefore crucial that in these negotiations, both parties can work with the policy to ensure a fair and reasonable outcome. It's going to be very, very difficult now this amendment's gone through, exactly how that would come about, sir. But as I say, we are where we are, sir, and I ask for the appel.
That is called for. The vote is on the adoption of the Minister's proposition as amended, and I ask the greffier to put a link in the vote, chat, I should say. And I open the voting and ask members to vote in the normal way. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The proposition has been adopted as amended. 35 votes pour, 7 votes contre, no abstentions in the link, and a further 2 votes pour in the chat. Very well. The next item of public business is the Migration Control Policy P137 lodged by the Chief Minister. For the purposes of this debate, the main respondent is the Chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion, A, to agree that action should be taken to provide more responsive controls on the number of migrants who acquire the right to settle permanently in Jersey, and to remove the automatic graduation from one CHWL permission to another. B, to request the Chief Minister to bring forward amendments to the States of Jersey Law 2005 to require the Council of Ministers to develop a common policy on population. C, to request the Chief Minister to bring forward the following amendments to the Control of Housing and Work Jersey Law 2012 CHWL. 1. To introduce a 9-month CHWL permission that does not lead to permanent residential status. 2. To introduce a 4-year CHWL permission that does not lead to permanent residential status. 3. To introduce a 10-year CHWL permission that may lead to permanent residential status. 4. To introduce a long-term CHWL permission that does provide permanent residential status. 5. To require the applicant for a new permit to make a declaration of any unspent criminal convictions. 6. To introduce enhanced identity requirements for all CHWL cards issued to new residents. 7. To provide for an independent statutory expert panel to research and advise on population matters. And 8. To provide for a committee of states members to hold responsibility for determining applications under the CHW law that fall outside formal guidelines.
Minister.
Sir, the Deputy St Peter, Deputy Hewlin, is acting as rapporteur on this, sir.
Thank you very much, Deputy St Peter. Deputy St Peter.
Thank you, sir. The number of people living within our island has been an ongoing subject for discussion over many decades, while our population has continued to expand despite a range of laws and policies designed to control that growth. Today, I hope that we will take an important step forward in addressing this issue and starting to solve one of the most challenging dilemmas that we face as Jersey politicians. It is very easy to confuse the separate subjects of migration controls, immigration and population. They are interlinked. However, I must emphasise that without migration controls, we will not be able to manage whatever population policy is agreed. Quite simply, we must have a means to stop poorly targeted growth. Otherwise, we'll find ourselves on a path to 137,000 or more by 2035. Today's debate is about these migration controls. However, we will be looking at all three areas as we go through this year. In summary, the debate today is on the principles of improved migration controls. I will then seek an in-committee debate on general population policy issues at the next state sitting. Using the output from the in-committee debate, we will draw initial themes for further development with ministers, the scrutiny panel, and interested states members. I will return to the States Assembly in the summer with a detailed control of housing and work law regulations that will flesh out the principles of migration controls, obviously subject to members' approval today or tomorrow. We will undertake a public consultation over the summer on the content of the first common population policy. We will pay particular attention to the island's recovery from COVID and the immigration situation following Brexit in drawing up a final population policy document. And then I will return to the States Assembly before the end of the year to debate that common population policy. Sir, I know the issue of migration controls is of great importance to members, and I'm very grateful for the large number of members who attended the briefing session last week. I would also like to extend my thanks and appreciation to the scrutiny panel, who have conducted a considered and thoughtful review, and I'm particularly encouraged by their full acknowledgement of the significant challenge and complexity of the work that lies ahead of us, and I'm fully confident we can work collaboratively during the rest of this year and beyond. The panel published their Phase 1 report last Thursday, setting out the results of their investigation into P137, and I'm pleased to say we've already accepted the first two recommendations of the scrutiny review. A report providing details on the relationship between the control of housing and work law and the immigration rules has been circulated, together with details of the associated fees. So whilst the relationship between immigration and migration is important, I must emphasise again that the debate today is just about migration controls. The immigration system works closely with the control of housing and work system, and an individual seeking immigration permission to work in Jersey will still need control of housing and work permission. The control of housing and work laws that we put forward will apply to everyone seeking to move to Jersey and take up work in the future. I can also confirm that I'll be accepting all three of the scrutiny panel's recommendations to publish information. As the scrutiny panel has identified, collecting and publishing detailed information will be a key factor in the overall success of any population policy. And in line with the panel's fourth recommendation, I'm also pleased that I'll be consulting with all affected business sectors over the next few months, updating and building on the detailed interviews undertaken by the Migration Policy Development Board during the course of 2019. So looking at the proposition in more detail, there are two main themes to the decisions in front of members. The first theme is to create clear and effective migration controls on access to the Jersey job market. The proposition seeks to remove the ability of migrants to automatically acquire the right to take up any job after 5 years. This is sometimes referred to as graduation. Today, a new migrant worker can take up registered employment for 5 years and then move into the wider job market, hence freeing up the registered employment permission for the employer to use again for a new inward migrant. This means that the total number of workers in the island continues to increase, even if no new registered permissions are granted to businesses. The government is therefore unable to control this expansion of the job market using the current controls available. So Part A of the proposition seeks an endorsement of the principle of removing this automatic flow. Part C1 to 4 replace the current set of controlling and housing work employment permissions with a new set which allow for short, medium and long-term permissions, but with only the long-term permission able to lead directly to permanent residence. C5 provides for improved identity requirements and creates a new criminal record check that does not currently exist in respect of British and Irish residents seeking to move to Jersey. And C7 provides for a strengthened decision-making process with an elected committee of states members determining difficult cases. The second theme of the propositions is to provide the political framework with which a common population policy can be developed. Part B of the proposition proposes that the State of Jersey law should be amended to create a formal requirement for the Council of Ministers to develop a common policy on population. This is backed by C6, which calls for an independent expert panel to be created to support that population policy. This should be formed of a small group, maybe 3 or 4, who are proven experts in this field. This is aimed at bringing in expertise from around the world with the sole aim of providing analysis and knowledge gained from other jurisdictions to enhance and inform the political decision-making process. And the final part of Deputy Prochard's amendment adds an extra part to this proposition to ensure that the expert panel draws on local consultation, and will be accepting that part of her amendment. So a keen challenge to this proposition is the big question: how can members be asked to agree with migration controls when they have not yet discussed the population policy itself? This is an important question, but the answer is clear. The current control of housing and work law does not give the government the migration controls it needs to implement an effective population policy. Using the analogy of a tap, the current controls act like a leaky tap. The automatic graduation of registered workers into the local job market make it difficult to limit population growth. P137 could be thought of as replacing the leaky tap with a new tap that could be turned up or down without leaking. The migration controls set out in P137 do not make any judgment as to the number of or type of people or businesses who will be granted these permissions. These controls could be used to increase or decrease the level of inward migration, to expand or restrict activity in any business sector. Now, developing the population policy will, as I have explained, take time. I will be requesting a committee debate at the next meeting, and then draft proposals will be drawn up to form the basis of public consultation over the summer, with final recommendations published in the autumn for debate before the end of the year. If we leave the leaky tap of current control of housing and work laws and controls in place now, we will then need to bring changes to the control of housing and work law back to the Assembly next year. This will create a significant delay in moving to more effective controls and being able to fully implement the population policy itself. Now, implementing the new migration control policy will mean changes to IT systems and customer-facing services. The State has voted £1 million to build a new IT system during 2021. The IT system will need to reflect the type of controls within the control of housing and work law. Delaying decisions on the type of controls until 2022 will create a further significant delay in developing and implementing the operational systems needed. So, members have also asked how the new controls will affect migrants' rights. The report on P137 addresses these issues and sets out details of 2 reviews that will be undertaken as part of the overall project to develop a population policy. Today, migrants are subject to a range of restrictions across different government services, which are confusing and can be difficult to navigate. And today, a relationship breakdown can lead to difficult housing and employment issues for migrant families. I'm determined to address these important issues, but these solutions do not fall within the migration controls principles that we are today discussing. Access to government services will be addressed as part of the development of the broader population policy. The treatment of families within the control of housing and work law will be included in the detailed law drafting proposals that will come back for debate in the summer, subject, obviously, to members' approval today. In particular, we will prepare a full children's rights impact assessment to accompany the proposed legal amendments to the control of housing and work law. So to sum up, the debate today on migration controls is just the first step in a number of actions to help us get to a position where we will have effective migration controls, detailed evidence on migration and population drawn from reliable data and informed consultations, agreement on a high-level population policy, a political structure can implement the policy and the controls, and clear guidelines and simple application processes to support businesses and migrant workers. Senator Pallett, in his forward to the scrutiny report, identified the urgency of needing to control migration and wrote, "Generally, it is accepted that new migration controls are both necessary and long overdue. The proposals presented to you today provide a clear step to creating those long overdue migration controls, and I urge members to support the proposition." I maintain the proposition.
Very much, Deputy Peter. Senator Moore, you asked to confirm the identity of the responder, I think. Do you wish to do that?
I did, thank you, sir. If I may just confirm, I may have misheard you, but Senator Pallett, as the chair of the review panel that has been looking at this piece of work, will, I assume, be the main responder, and I believe that is set out in the order paper.
Yes, indeed, you're correct. It is Senator Pallett. Thank you very much indeed for that clarification. Very well. There is the proposition seconded?
Yes, sir.
Yes, sir.
There are two amendments to the main proposition, one from Deputy Pershard and one from the Migration and Population Review Panel. There's also an amendment by the Chief Minister to the Deputy Pershard's amendment. Deputy Doublé, you're acting, I believe, as rapporteur for Deputy Pershard's amendment in accordance with Standing Order 71A.
I am indeed, thank you, sir.
Very well. Are you able to indicate whether you are minded to accept the Chief Minister's amendment to Deputy Pershard's amendment?
The amendment is not acceptable to Deputy Pershard.
Right, very well. Then I ask the greffier to read the amendment unamended.
Page 2, paragraph B. For the words "a common policy on population," substitute the words "by the end of December 2021, a common policy on population as outlined in Migration and Population Data P120 of 2020, adopted as amended by the Assembly on 4th November 2020, that is reviewed and updated annually based on the prior year's population growth, and that includes annually updated infrastructural, educational, health-related, environmental and social requirements of any projected population growth." Paragraph C, for subparagraph 7, substitute the following subparagraph: to provide for an independent statutory expert gender balance panel, the members of which are actively sought from across the globe and who have proven expertise in small island populations defined as populations of 500,000 or less, to research and advise on population matters. Paragraph C, before subparagraph 8, insert the following new subparagraph and redesignate subsequent subparagraphs accordingly. To ensure that the panel established in accordance with subparagraph 7 as one aspect of its wider research will engage with a representative sample that is reflecting the common characteristics of the Jersey population by way of consultation.
Thank you, sir. The purpose of the expert panel is to provide expert advice on the development and implementation of migration controls. Since the adoption of Deputy Pershard's proposition calling for a complete population policy to be brought to the Assembly during this political term, it has become apparent that this Assembly wants a clear vision from government of the future of our island's population size and management for the long-term future. Part 1 of this amendment makes explicit the definition of the Common Population Policy, aligning it with that which was outlined in P120 2020, Migration and Population Data, and as adopted by an overwhelming majority of this Assembly on the 4th of November 2020. The effect of this is to ensure that the data referred to as sustainability data in P120 is required not just in the policy approved for the end of this year, but must also feature in subsequent population policies. Part 2 of this amendment asks that the Assembly approve 2 important criteria for the overall makeup of the expert advisory panel: gender balance and small island expertise. To address the first point, gender equity, it is widely accepted that in order to improve diversity in any context, whether an expert panel, board, organisation or other group, targeted intervention is required. The meritocratic best person for the job line, often used to object to these targeted interventions, has been widely debunked as nonsense. This argument is, unsurprisingly, often used by those who have themselves benefited from centuries of positive discrimination towards their own characteristics. It is understandable that some find the idea of redressing this imbalance threatening. But we have to be honest with ourselves about the real reasons for unequal representations at the most senior levels. We need to address them so that we no longer positively discriminate against any particular group at the expense of others. When it comes to an expert panel advising on the future of the population of our island, we need a panel who are to some degree representative of the community. Deputy Pershard has already agreed a change from her original lodged amendment to reduce the restrictions she had placed in terms of the diversity of the panel. This is as far as the Deputy could go with the compromise sought by government. Any less than this would not have been a compromise at all, but a complete abandonment of her attempts to improve diversity. She has settled for the bare minimum, and yet the Assistant Minister still intends to fight the amendment. This is neither collaborative nor demonstrates any willingness to compromise. We are already woefully behind the business community and the corporate world when it comes to addressing diversity at senior levels. When it comes to gender parity, we should be leading, not dragging our feet. To address the second point, small island expertise. Jersey, along with other small island communities around the world, faces unique challenges when it comes to managing the space, people, size and resources that we have. We need to have a position on the number of people the island can hold, not just in terms of housing, but in terms of the demand for schools, road usage, amenities, land, resources, cars, the natural environment. And what we also need are controls that are appropriate to the vision that comes with the population policy. Therefore, it is essential that those advising on such controls have a particular understanding of the specific challenges of managing the population of a small island community. Therefore, it is Deputy Pershard's view, and my own, that the members of the expert advisory panel should have proven expertise in small island population controls. For the purposes of this proposal, the Deputy has used 500,000 people or less as a benchmark for what constitutes a small island population. This is based on the population size used by the Commonwealth Parliamentary Association to define small branch jurisdiction in their 2021 to 2023 strategic plan. Part 3 of this proposition calls for the expert panel to consult as part of the research they will be undertaking with a representative sample of the population, that being a sample whose characteristics proportionately reflect those of the wider population. The rationale for this is obvious. The views of the population on matters pertaining to migration controls need to be captured in such a way so as not to favour nor discriminate against any particular characteristic or group. Sir, I make this proposition on behalf of Deputy Pershard.
Thank you very much. Is the proposition for the amendment seconded?
Yes, sir.
Very well. Now there's an amendment to that amendment proposed by the Chief Minister, and I ask the referee to read that amendment.
Page 2, part 2. In the new subparagraph 7, for the words gender balance panel, substitute the words panel appointed subject to the oversight of the Jersey Appointments Commission. In the new subparagraph 7, for the words who have proven expertise, substitute the words at least one member of which has proven expertise. In the new subparagraph 7, for the word island, substitute the word country.
Is this also the Deputy of St Peter?
Yes. So we've got some feedback. Can we? I apologise for the technology. I think we're okay now. Thank you, sir. Apologise for that. So I've discussed Deputy Pershard's original amendment with her, and I'm grateful to her for some of the changes she has incorporated into her second amendment. However, we were not able to come to agreement on a few issues, and as such, the Chief Minister has lodged this amendment. This amendment relates to the composition of the expert panel that would provide advice to the government in developing and maintaining a population policy. The expert panel being proposed is likely to comprise 3 or 4 members, with each panel member providing advice in a specialist area to help the council ministers to develop and maintain a common population policy. Experts will be drawn from around the world and will bring experience in areas such as labour, market economics, skills policies and population modelling. Deputy Pershard's amendment specifically requires the panel to be recruited to create a gender balance. This amendment removes this restriction and places it with an explicit reference to the Jersey Appointments Commission. Now, quoting directly from the Deputy's report, as previously quoted by Deputy Doublé, she suggests that the meritocratic best person for the job line often used to object to targeted inventors has been widely debunked as a nonsense. This is directly at odds with the current policy of the Commission. The Commission was set up by the Assembly to ensure that senior appointments receive independent oversight and are subject to a strong commitment to diversity within the recruitment process. The Commission's recruitment guidelines commit to advertising each role in such a way as to encourage applicants from all sectors and groups, and that selection techniques are reliable, guard against bias, and are in line with discrimination legislation. The Commission's current framework is, however, very clear that appointments should be made on the basis of an individual merit, regardless of race, gender, age, or any other personal factor. So until the States Assembly decides to change the remit of the Appointments Commission, I do not believe that it is appropriate to include gender requirements as part of the recruitment process for a panel of population experts. The Chief Minister has also proposed 2 other minor changes to the wording. Deputy Pershard's wording requires every member of the panel to have experience of small island populations. The amendment from the Chief Minister amends this so that at least one member of the panel should have this type of expert knowledge, and the requirement is widened to small country experience rather than small island experience. I ask members to support these changes, and I maintain the amendment.
The amendment seconded.
Yes, sir.
Any member wish to speak on the amendment? Grant Harbison 1.
Sure. Thank you, sir. I think I need to speak now because if this amendment is approved, it will amend Deputy Pershard's amendment and amend the bit that I have a concern with. So this is, I have to say, a speech I didn't really want to make. I have the greatest respect and admiration for Deputy Pershard's views and beliefs when it comes to achieving gender diversity. Not least because I share many of her views on this subject, and I'm particularly sorry that she's not in the Assembly today, and if she's not well, I don't know that that's the case. I hope she makes a speedy recovery. Indeed, so during my working life prior to becoming a States member, gender balance is something I've worked very hard to achieve in the teams and organisations I've managed and led, and for two reasons. Firstly, and most importantly, it is the right thing to do. It is, in my view, nobody should be excluded from succeeding because of their gender. And secondly, from a purely practical perspective, gender balanced teams are more rounded and as a result, in my experience, are generally higher performers and achieve better results. And in the world I work in, results and performance are everything if you want to succeed. So we come to the first of the Deputy's statements in her report, which gives me concern, and to quote her directly, "The meritocratic best person for the job line is often used to object to targeted interventions and has been widely debunked as nonsense." So to which I would respond, actually, appointment on merit is the only game in town. To do anything else is in itself a flawed argument which does not stand up to examination. The real answer is to do the work to ensure that everyone has an equal opportunity to be appointed to these roles. And I'll cover that in a bit more detail later on. So let us look at a hypothetical example of how this amendment might work in practice. A possible scenario might play out as follows. The selection team have chosen all bar one of the new proposed panel and have achieved gender balanced and the best qualified so far. However, for the last position, they have a choice between two candidates. One who is better qualified but the wrong gender to achieve the required balance, and one who is appointable but of lesser ability but the right gender. If this amendment, if Deputy Pershaw's amendment is approved or not amended by this amendment, then they would be in the position of having to possibly appoint the lesser candidate simply because the person is of the right gender. I accept that this is a simplistic argument, which any intelligent panel, if they use their nous, could avoid. However, it is the principle behind this that sticks in my throat. And to follow this up, and very emotively I accept, the challenge is simple. How would the Deputy feel if it was her in this position, in that a man of lesser ability than her was appointed to the panel simply to make up the gender diversity numbers? To mine, this smacks of taking a shortcut to get to the desired result, a shortcut. It also flies in the face of all the gender legislation, all the diversity legislation this Assembly has passed, which has as its guiding principle that it is illegal to discriminate against anyone because of their race, gender, age or ability. So let us look at the second comment the Deputy makes in her report. And I'm paraphrasing her comments. This argument, referring to her earlier comment on meritocracy, is unsurprisingly often used by those who themselves have benefited from centuries of positive discrimination towards their own characteristics. It is understandable that some find the idea of redressing this about threatening. We have to be honest with ourselves about the real reasons for unequal representation at most senior levels. We need to address them so that we no longer positively discriminate against any particular group at the expense of others. However, I make the point that if this proposition is adopted, this could exactly be what might happen to achieve the desired gender balance. That said, the bulk of her comment is entirely correct in that for centuries we have seen a world dominated by men, the exclusion of very talented women. I've seen this for myself in the finance industry, where the management teams were made up exclusively of men. In my early years in the 70s, with a few exceptions, women largely managed the cash tills, typed and made the tea. Furthermore, many of the male management appointments were made on the basis of which school you went to, which club you were a member of, or whether you had any aristocratic connections. Talent and ability were merely afterthoughts. Thank goodness those days are behind us, and we live in an age where ability is in most cases the key quality employers look for. However, as the Deputy knows, there remains much to do to ensure women are given exactly the same opportunities to succeed, attain the most senior levels in business and indeed in all fields, including public service. This work has made good progress, including our own public service, but there remains a long way to go to achieve parity. Diversity will only be achieved by, amongst other things, ensuring access to appropriate talent training, such as the I Will initiative run in the public service workforce, and also includes such initiatives as opportunities to shadow existing directors and senior management in work, educational opportunities, family-friendly HR policies which encourage both partners to share equally parental responsibilities, and the elimination of the gender pay gap. These, in my mind, are all examples of the ways to help break the glass ceiling and will help to achieve equal opportunities for both genders. So in my view, it would have been perhaps a better way forward had Deputy Pershard suggested that the application process for this panel was as gender neutral as possible, by insisting on the use of blind CVs, ensuring the selection panel must undergo or have undergone unconscious bias training to ensure a balanced field of candidates for this board. The point that I'm trying to make is that there's no shortcut to achieving the aim of ensuring both genders have equal opportunity representation at the highest level. We need to do the work. We need to do the work and put in place mechanisms which ensure that women have as good a chance of being appointed to high office as men. Let us not take tempting shortcuts, which in my view compromise our diversity principles and may hinder the ultimate goal of diversity. The Jersey Appointments Commission guidelines in this amendment state that, amongst other things, appointment on merit must be the overriding principle governing the appointments process. Applicants must be considered equally on merit at each stage of the selection process. The principle of equal opportunity and diversity must also be inherent within the process. This, to me, seems the appropriate way to make these amendments to this panel and not as suggested by this amendment. So I cannot support Deputy Pershard's particular paragraph because not because I'm opposed to gender diversity, quite the reverse. I just don't believe that the force of the issue is the way forward and will have longer term consequences to real progress in that direction. Thank you, sir.
Much, Conor Tubb. Deputy Burrell.
Thank you, sir. I wasn't sure if Deputy Ash should go first because I think he got in first, but you've called me, so I'll stay here. Sir, I'm going to speak against this amendment to the amendment, but I want to make it quite clear, and I will speak strongly about this in the main proposition. This actual aspect of the proposition about appointing a panel is, in my view, a very dangerous road to go down, full stop. And so Deputy Pershard's amendment, I think, is a good way forward should that part of the main proposition pass. But I hope, and I am asking now that when we get to the main proposition, we divide it so we can vote on different parts of it separately, because I believe appointing a panel full stop is the wrong thing to do. But turning to Deputy Pershard's amendment, and specifically this amendment to the amendment, and having listened to the Constable of St. Juan, it raises a few issues for me. First of all, I have to address the issue of shortcuts. And when I hear the Constable of St. Juan talk about there being no shortcut, all I have to say to that is, believe me, women know there is no shortcut. They've been waiting millennia for gender equality, and they're still waiting. So I don't think the Constable of St. Juan lecturing them on shortcuts to gender equality is particularly effective. Also, the Constable of St. Juan said that we should no longer positively discriminate against any particular group. I have to ask there, when has the government discriminated positively against any particular group? If there is any positive discrimination, I would suggest, as we've seen just in the almost 3 years I've been in the Assembly, that the only positive discrimination is towards men, as many more men have been appointed to boards than women over the course of the last 2.5 to 3 years. So this attempt at positive discrimination that is being described by the Constable of St. Juan is spurious. And indeed, I would argue that asking for a gender balanced board or panel isn't actually positive discrimination. It's treating men, women and other genders equally. It's saying just balanced, please. It's not saying one or the other. It's saying we want an equal amount of genders on the board. I would then say, sir, if we look into other parts of the amendment to the amendment, I think there are problems here as well. The amendment asks that we don't look for people with expertise in small islands, rather it asks for people with expertise in small countries. I think that's a ridiculous road to go down. Small countries do not have in any way the same population dynamics as small islands. Take a small country like Switzerland. Now, many people who work in Geneva live in France. So Geneva has a working population, many of whom don't live in the country of Switzerland. That's how small countries can operate. That's an option that is never open to a small island like ours. So it's a completely wrong road to go down to suggest an amendment that says expertise in the population of small countries. That person may as well not be on the panel, because their expertise would not be relevant to that of a small island. And so also, I do also question, I just need to double check that this is part of the right, but that's it, the panel being appointed subject to the oversight of the Jersey Appointments Commission. And here, sir, I sadly have to raise the issue of the Jersey Appointments Commission, which in many of the past 3 years that I've been in the Assembly has been the elephant in the room, as we've seen people appointed to positions in the executive who have previous experience with the chief executive, for example. They're making many members of this Assembly question what it is the Appointments Commission is signing off on in terms of regulating the appointments process. I believe, and I stand to be corrected, but I believe there are many members of this Assembly who do not believe the Jersey Appointments Commission is a body that should be regulating this sort of thing, because it needs an overhaul, because we have not seen over the past 3 years fairness in appointments to the executive. So, sir, this is a very brief speech, and sorry it is fairly stilted, but I'm responding to the connotables and one. And I ask members to look at this amendment to the amendment and understand that it doesn't work. It doesn't work in terms of getting rid of the gender balanced approach, which is a perfectly reasonable approach. There are approximately 50% women to approximately 50% men, and I apologise to non-binary people for excluding them in that calculation. So as there's a gender balanced population, why should we not have a gender balanced panel? Small countries are not small islands. They have completely different dynamics. The experience from a small country is irrelevant to the experience of a small island. And sir, sadly, I cannot endorse the oversight of the Jersey Appointments Commission for the many reasons that many members of this Assembly will understand. So, sir, I ask members not to support this amendment to the amendment. Thank you, sir.
Very much. Deputy Doublé.
Thank you, sir. And I'm pleased to follow the previous speaker. And I too would like to respond to certain things that the Constable of St. Juan mentioned in his speech. And the Constable has been a welcome ally in diversity work in the past. So some of the things that he said in his speech, I was quite surprised by, actually. And there was a phrase that he used, and he was talking about inequality and experiences that he'd had from his days in the corporate world, and he said that those days are behind us. And so I was so surprised to hear that, and you know, I might ask the Assembly more generally, not just the Constable, but the Assembly more generally, to have a look at the gender pay gap report, which this work, of course, has been delayed, like so many things in the last 12 months by COVID, but we must return to that work because those days are not behind us, sir. Those days are very much still upon us. I've just seen Deputy Higgins in the chat asking if I'm speaking on behalf of Deputy Pershad or myself. I'm speaking for myself here, sir. We are far from being an unequal society. The concept of unconscious bias, in fact, it is something not that we have addressed and is behind us. It's something we're only just beginning to address ourselves here in the Assembly, and it is very much not resolved in wider society. And so at the current rate, it is going to be several decades before we achieve true equality between men and women. The Constable also mentioned that perhaps a gender neutral application process would be something he would have preferred. And whilst I can see that that would be better than a process that does not take That would be better than a gender blind process, which is a process that doesn't consider gender at all. A gender neutral application process is not the ideal. A gender sensitive approach is the ideal, and that's an approach which takes into account the differences in the ways that our society impacts on men and women. And this is the approach that Deputy Pershard, I believe, is taking. And it's an approach that would be erased if this amendment to the amendment were accepted, sir. So I am speaking against the amendment to this amendment. I want to address briefly the concept of meritocracy, and the Deputy Pershard in her report to her proposition mentions meritocracy, and I did some research on this myself, and actually this is something that when Deputy Pershard joined my review panel into gender pay gap, even though I was an equality campaigner myself already, sir, there's always things that we can learn from each other, and especially I think members who have been around a bit longer can learn from newer members. And we had some fascinating discussions on the concept of meritocracy. It was Deputy Pershard that introduced the new thinking to me, actually, around meritocracy. And anyone who does a quick Google around this, a Google search, can uncover a wide range of research and academic commentary on this. And the recent thinking, sir, is actually that meritocracy is now widely understood to be a concept that actually ingrains privilege. So we do need to be careful that whilst we are advocating for things which we believe to be fair, and I do believe that there are good intentions, because you know, members generally do want to do just what is best, but that the idea behind what is best for equality is evolving, sir, and meritocracy is no longer the ideal, because merit, so factors which indicate merit in a particular society are likely to be set by the people in that society who hold power and who themselves are in senior positions, and that is the way in which it can ingrain privilege. So really we shouldn't be actually aiming for a meritocracy. And what I want to also address is the Jersey Appointments Commission, and Deputy Morell made some excellent points on this. And you know, nobody wants to disparage the work of the Commission, because they do excellent work, but there is always improvements. There are always improvements to be made for any of the work that we are doing, and we must be able to reflect on this. And so the Commission was set up, I believe, nearly 20 years ago. And I do wonder if it's time for a review of those processes to see whether they are the ideal, and whether they are helping us to aim as high as high as we would like to aim in terms of equality and diversity. Because I do feel that sometimes we use the Appointments Commission as something to hide behind when we end up with boards and committees that are not diverse. And we like to think that we've done all we can do to strive for diversity because the appointments have gone through the Commission, and that box is ticked, and let's not think about that anymore. But so the way that I see it is the Jersey Appointments Commission processes, those are the bare minimum, and they are not the entirety of all we can and should do in this respect. And I have to disagree, sir, with what has been put forward by the proposer of this amendment to Deputy Pershard's amendment, because this Deputy Pershard's amendment in no way subverts or overrides the Appointment Commission. The usual processes can take place, but what we will have, if we approve the Deputy's amendment unamended by this amendment, is something that goes above and beyond and will actually add to the Appointments Commission processes. And So as an example, sir, of when we have maybe done this in the past, and Deputy Morell was one of the other members who was the driving factor behind this, as well as Deputy Pershad and myself, and I believe Deputy Ward. So several members of this assembly in recent months requested additional information on potential trustees when several appointments came before us. And these appointments had gone through the Appointments Commission, but we felt that we wanted additional information. And this was accommodated by ministers. And, you know, we have started to see, I think it was Senator Farnham, who is showing an increasing interest in these issues. Senator Farnham has brought forward additional information since those discussions. So, sir, there is already a precedent whereby senior ministers are showing that there is sometimes a need to go above and beyond to achieve diversity. And what is the subject that we're talking about today? The subject of the main debate today, it's migration. And the amendment that Deputy Pershad has lodged, and which I have proposed on her behalf today, will have a hugely positive impact on this policy area if it is passed in its original form. Issues around population and migration are possibly the most critically important to our island, and many islanders would say this is the most important piece of work that will be carried out by government. So I do think that we should be going above and beyond the established processes of the Appointments Commission because of the importance of this subject. And just a quick note to finish on, and this is something that Deputy Pershad flagged up to me, and she recalled a public hearing that we had at the time of the Gender Pay Gap Review, and we had the Appointments Commission, the chair of the Appointments Commission in for a public hearing, and we were discussing meritocracy. And Dame Janet, and this is a quote, and she said, "If you are looking for the most meritorious candidates, then diversity is part of that. There will be many jobs where if you are looking at a member of the team, one of the strengths you may well want is a diverse range of experience. If you are looking for the merit that will come with that range of experience, you will automatically look for somebody who can bring that different range of experience to the team." And in a separate answer to a question by Deputy Pershad in that hearing, Dame Janet also said, the greater the diversity, the richer the outcome. So I believe that it is absolutely the best thing to do to approve the amendment unamended, and I believe that members, if they do want to strive for the highest standards of equality and diversity for this extremely important policy, they should vote against the amendment to this amendment and for Deputy Pershad's amendment. Thank you, sir.
Thank you very much, Deputy Doublé. Senator Balwar, you've indicated you have a question for the Attorney General.
Yes, thank you, sir. So my question surrounds the employment of the States of Jersey Employees Law, under which the Jersey Appointments Commission are governed. And on the amendment to the amendment, it refers to an independent panel. So the first question is whether that comes under the definition of the law under Article 1 as an independent body. And therefore, if so, my second question is, what impact does Article 15 therefore have on the guidelines and the independence of that body, whereby the State's Employment Board can overrule an agreed list under paragraph 1 or 3 of that said Article 15? Thank you, sir.
Mr. Attorney, do you need time to consider your answer to that, or can you assist the Assembly?
So it's the Solicitor General. I wonder if I will need some more time. I wonder if I could trouble the Senator to repeat the second question, please.
Yes, my first question was around the independent body. So my second question followed that up by the Article 15, which references the ability for the State's Employment Board opinion to prevail over an agreed list under paragraph 1 or 3 of that said article. So I wonder whether that has an impact on the ability to appoint under the said amendment that we're discussing at the moment in terms of statutory compliance, and whether it's a role of the State's Employment Board or whether it's the role of the Jersey Appointments Commission.
And I note, Deputy Tadier, you also have a question for the Solicitor General. Deputy Tadier.
Thank you, sir. So I wasn't sure if that question was going to be answered first, but I can ask mine now. It relates to the wording in the amendment, which talks about, specifically the wording which I find slightly strange, but it may be that it's got a natural meaning that is understood, about members of the panel being actively sought from across the globe. What does the Solicitor General think that would bind us to do as an assembly?
Mr. Solicitor General, I'm assuming you'd wish the opportunity to reflect on both of those, as you've indicated you want to reflect on the first one.
Yes, please.
Very well. Well, I'm not sure how fast we'll move, but it seems to be there's a significant amount of the debate still to go. So it's likely that you'll be in a position to, you may well have the overnight adjournment to consider it, but we'll have to see how the Assembly wishes to continue. Very well. Deputy Ash.
Thank you, sir. I was in that short break, I was just reflecting on Deputy Tadier's amusing comment this morning when he was talking about answering questions. When you ask a question on the colour of the roof at Fort Regent and someone answers with a answer on GST. Well, one way or another, we seem to have done pretty much similar on this debate. We've moved from a debate on migration to diversity and the Jersey Appointments Commission. So we cover a fairly wide canvas when we do these debates. What do we need to look at, sir, in this? Do we look at, with migration, we should surely be looking at the strain on our services, hospitals, schools, bin collections. It's a massive list, so we really should be looking at that. Should we be looking at the needs of business, hotels, restaurants, pubs, shops, finance, all needing staff, agriculture? Get that wrong, as we did with finance licenses some 20 years ago, and the consequences are far-reaching. For those of you who don't remember that, it became very difficult for banks and finance institutions to get licenses, which forced up salaries, particularly support staff salaries, to levels that were in excess, in some cases, of the City of London, and to my mind is responsible for the dwindling number of banks that we now have operating in Jersey. So should we be looking at those things, or should we be looking at the diversity of a panel? So I tend to agree with Deputy Morell. I don't really believe we need a panel. We should sit down amongst ourselves, work out what we need to address and address it with perhaps a little bit of help from others. But to get down to the nitty gritty of, which I believe we can now use that expression, if we can't, I apologise, of the diversity manual, which is being put to us. And I think the Constable of St. Juan summed it up really well when he said to put down there that we don't any longer look for the best person for the job. What are we looking for then? The most mediocre person for the job? The worst person for the job? Surely we have to look forward to getting the best person we possibly can in Jersey for jobs, for any vacancy. And that the the risk of sounding like a member of the 60s pop group The Monkees, sir, I'm a believer in getting the best people for the job for any vacancy we have. I'm also a believer in having a diverse selection policy and getting that, in having diverse appointments panels to find those best people. And I'm a believer that the JEC follow the principles of equality in their selection process, so that this amendment, in my opinion, is unnecessary. If people don't think the JEC are doing that job, someone needs to bring something to the States Assembly and we'll change it. But for the moment, we have to accept that that is the correct procedure and one that is working. Not only though, sir, this time have we been given the diversity panel dilemma that we seem to get every time when we appoint a panel. We've also got the other assertion that every member should have experience of small island populations. Every member, sir, not one, every member. Well, what is that going to achieve? Many islands are now faced with the problems of dwindling populations. Is that relevant to us? Many will have no major finance industry, which needs to be staffed, or indeed an agricultural sector that will need to be staffed, or a tourism sector that will need to be staffed. So is that relevant to us? Many will have very poor connectivity or in being remote jurisdictions. Is that relevant to us? To put these broad swathes of, yes, we must do this, and is populism at its worst, and it needs to be stopped. We must go down finding the right people to do these jobs, these panels, but people who really know what they're doing, what they talk about, and more importantly, what is relevant to this island. Let's close this debate as soon as we can. Let's get on with sorting out a migration and an immigration policy that this island has been long overdue. Thank you, sir.
Thank you very much, Deputy. Deputy Taddy.
Thank you, sir. It does seem slightly strange that we find ourselves in a position of trying to identify what kind of statutory panel that we might like to have before deciding whether we'd like to have that panel. It's beginning to get a little bit like angels on pinheads. You know, how many angels can you fit on a pinhead? Well, let's decide first whether angels exist before we decide what size they might be and whether they can fit on the head of a pin. So whilst I probably come to a different conclusion from the normal reactionaries in the Assembly who might have expounded up till now, I do think the thought process is still one worth looking at, because we are a debating chamber after all. And what strikes me in the wording is that, I mean, let's work on the basis that we are going to have this panel for now, and so talk about what it might look like. We're being asked for some particularly interesting things. So it has to be a statutory panel, it has to be independent, and it also has to be comprised of experts. Now, I don't know exactly what the market is like for experts on this kind of thing throughout the world. I don't know whether the field of experts is gender balanced, for example. So I don't know if the great minds on this happen to be male or female, or what the proportion and distribution of those experts are. So technically it could be an issue if it turns out that 90% of the experts that are well known and on the market to put themselves forward for this kind of work happen to be female, then it might be difficult to get a gender balance, because we find out that there might not be very many who offer those services. It could well likely be the other way around, sir. And I think there will be different reasons for that. And then it says we want a gender balanced panel. Now, I do believe we need a gender balanced panel, probably, but for different reasons. For example, to what Deputy Morell might have said. Deputy Morell said that because half of the population are female, it must therefore follow that half of this panel should also be female. But I think if we use that logic, we could say that for other traits of the population. For example, we could say that half of the population have an IQ of less than 100, which axiomatically must be true, because obviously IQ is based on 100 being the mean as well as the median, and therefore half of the population will have an IQ of less than 100. So we could say that we want half of the people on this panel to be of a perhaps less well off in the intelligence quotient department, although they may have other skills to make up for it. But we wouldn't do that necessarily, because it's supposed to be an expert panel. We could say, for example, we want half of the not half, but a proportion of the panel need to be racist, because certainly in my view there's no shortage of some quite choice Neanderthal and racist views in the population. And so, at a guess, we might say 30% of the population are racist. Therefore, we should have 30% of this panel who are racist, especially if we're dealing with things like immigration. But of course, that's a non sequitur, so, because there are other reasons. And you get into again, there could be conflicting areas here about expertise versus other qualities that we're looking for specifically. I think a good reason, though, for having a gender balance is not because half the population happens to be one gender or the other, or one sex or the other, but rather I see it in terms of building a house. So, for example, you say I need to build a house, and I will need an electrician for that. I'll need a carpenter, and I will need somebody to do the roofing, just for want of a few examples. And we don't say to them, but that's discriminating, because of course, what happens if the three best work persons that come forward all happen to be electricians? It should be a meritocracy, shouldn't it? You should employ the three electricians to come and do your house for you, because they're the three most qualified, and the electrician is more qualified than the carpenter. But we don't do that if you're building a house, because you need to get people with the requisite skills. And I think it recognises the fact that different genders do bring something different to the table, both in terms of their approach, their problem solving. And if you want to get to the point, of course, where we do have inbuilt gender diversity, and it shouldn't just be about gender, of course, we could have looked at this in terms of race, or in terms of other traits which we think are beneficial, then we could have put those in. But the reason I asked my question about the wording from across the globe is that we're asking to recruit actively people from across the globe, and also the bit about small island populations. Sorry, I'm trying to cram a lot in here, so I'm going to talk about these small island populations. And the point is here, I think that's the wrong test, is that Jersey isn't simply a small island. It's actually an island which is not sovereign, and which is attached to a much bigger sovereign nation. And also it has to adopt at least part of that nation's immigration policy. So it's bound by that immigration policy necessarily, in a way which other countries or islands with a population of less than 500 necessarily bound. So, for example, it could be that Vanuatu, or Vanuatu, for example, Samoa, that those islands would have less in common in Jersey in terms of trying to find an appropriate population policy than Scotland might, even though Scotland has a much larger population than 500,000. I think it's got a few million, hasn't it? They probably share some of the similar problems that Jersey has, although not right across the board, of course. They've got much more space, but they are a semi-autonomous country which can make some of its own decisions, but not all of them, because they remain a British island. And so I would question whether that test that's been put in for people having expertise in small island populations is necessarily correct, given the fact that we don't have all the mechanisms at our disposal in order to deal with the population pressures that other islands, which are completely independent or sovereign, may have. It also stands to reason that if we're actively recruiting from around the globe, that not all the people who put themselves forward may be entitled to work in Jersey, which is again could be seen as a paradox or an irony when it comes to appointing an expert panel to tell us what to do on population issues, when they themselves may not be allowed to work here, and we might have to change the rules to even constitute that. Again, there might be people closer to home who can provide those expertise there. So very much, I apologise for a slightly rambling speech, and you may say, sir, it's no different to usual, but just some thoughts about why I think I can support some of this, but the rest of it is maybe more nuanced.
Thank you very much, Deputy. Mr. Solicitor General, you've indicated you're ready to advise the Assembly.
So yes, can I deal with Senator Valois' question first? Under Article 1 of the States of Jersey Employment Law, a panel of the kind that is envisaged in this amendment, it seems to me, would constitute an independent body for the purposes of that law. If we then look at Article 15, which the Senator asked about specifically, let me just find it, forgive me. Under paragraph 3 of Article 15, the States Employment Board and the Jersey Appointments Commission are able to agree or not agree, as the case may be, to a list of appointments which constitute independent bodies for the purposes of Article 1. So they could agree that appointments of members to such a panel should be on the list for the purposes of Article 15. If they can't agree that such a panel should be on the list, then it's right to say that the view of the States Employment Board trumps the view of the Jersey Appointments Commission, which is to say it would then be for the States Employment Board to decide whether members of such a panel should either be on the list or not. The effect either way, as I understand it, is this: if the panel is an independent body for the purposes of the law, then appointments to it will be overseen by the Jersey Appointments Commission. If it is not on the list, then appointments to that panel would be determined by presumably whatever structure is put in place in any amendments to the Control of Housing and Work law. So I hope that's helpful. I wonder if I can then turn to Deputy Tadier's question. For my own part, I find the meaning of the phrase actively sought from across the globe, it is sufficiently vague that it's really not susceptible to any legal definition in terms of what it commits anyone to. It seems to me it's much more really a matter of policy and an expression of policy, which it will be, if it's given effect to, for those making the decision to decide how best to honour it. But it's a phrase that is too vague for me for legal definition. I hope those answers are helpful.
Thank you very much, Mr. Solicitor General. Next to speak is Deputy Labby.
Thank you, sir, and I'll keep it short because this debate is already in danger of being incredibly repetitious. The states of Jersey should be constituting committees and panels and boards that are diverse and gender balanced, period. We should not have to be explicit on certain committees and panels. Secondly, from my experience attending CPA conferences in both Canada and the South Pacific, the biggest problem for the majority of small island nations is dwindling population, not the other way around. which I think Deputy Ash said. So I'm going to keep it that short because I might have just repeated what other speakers have said. Thank you.
Well, Deputy Ward.
Thank you, sir. And I will speak briefly, and I don't think Deputy Doublé will mind what I'm about to say. And I want to deal with one particular issue, and that is the issue of this myth of meritocracy that was spoken about. And I think it does need to be addressed, and some understanding of it needs to be understood. The argument is, sir, that actually discrimination is integral to the merit-based system and the myth of what we would call the myth of meritocracy. It discriminates on how much merit a person has, but it must assume a precondition that everyone has equal opportunity to acquire this merit. And that's the key. And let's be honest, we do not have in our society equal opportunity to acquire the type of merit that we're talking about. In addition to that, what defines merit is often inaccurate and defined by those who hold power. For example, there is a paradox in the meritocracy argument. Studies have shown that when merit is used as a basis for performance appraisal, men had higher salaries increases compared to equally merited women. And the reason is that merit as a criteria is directly related to gender stereotypes and unconscious bias. Both of these factors exert influence on decision making and any merit-based decisions. So the masquerade of merit can actually have the reverse effect on creating diversity. This demonstrates where we need to address our unconscious bias, and that is something that I don't think that we have done successfully or even attempted to do successfully so far. And we must remember that the focus on merit does not make us immune from unconscious bias or gender stereotyping, and the more aware of that we are, however difficult it is, and you know, sometimes I think we have to accept the simple principle that it's, well, as in the words of the goddess of pop, it's better the devil you know. So I would urge people to reject the amendment of the amendment and move on from the myth of meritocracy, which has been spoken about. So if you believe that you are impartial, it gives you permission to act on biases. And when people themselves view themselves as unbiased, then they are less likely to self-scrutinize. So it's very important that we write in gender balance to these panels, as with other diversity balance, if we are genuinely to make the decisions that will be successful in the long term, particularly around the area of migration. Thank you, sir.
Thank you very much, Deputy. We've almost reached 5:30, when I'm required to ask the Assembly how it wishes to proceed. I've seen both Deputy Higgins and Senator Farnham seek to propose the adjournment. I'll take Deputy Higgins's proposition for the adjournment. The adjournment is proposed.
Seconded, sir.
It's seconded. Very well. In which case, the Assembly stands adjourned until 9:30 tomorrow morning.